Yes. Order for 10 is. Yes.
May I continue order 41
with application.
application?
May I trying to mention on matrimonial appeal hearing. The thing is that the husband and the wife has been living separately for the last 17 years.
Appeal we can't add now. Yes. Order 41 and applications, please hand over. Application, order 41, hand over.
Hearing
First
matrimonial
appeal, one stay application and my condonation appeal.
Application, yes, applications hand over.
my lord, hearing matrimonial matter, my lord, my lord.
Yes.
My lord, wife filed 125
of 2006
Appeal hearing?
Lozima matters, lordship. Lozima matters.
Yes.
My lord, my case, my lord,
For hearing, my lord, matrimonial appeal, my lord.
Not taking now, Mr. Dhol. Yes.
First appeal hearing.
No.
Well, paper is complete.
No.
For probate application hearing, Lord.
Application or what?
Hearing of
No. Hearing no.
Lordship.
Yes. What is the matter? Application or order 41? Admission. What is the appeal number?
Appeal number. Just a minute. 225 of 2025.
What is the appeal number? What is the caption?
FA number
FA is not admitted. So it's not an admission hearing matter. Sorry, no, not now.
contempt application, your lordship.
Contempt, yes.
My lord, I pray for inclusion in the list, my lord.
What is that?
It is an appeal from an order, my lord.
Appeal admission, it has been admitted.
Yes, my lord, there's an FMT number, my lord.
No, we are not taking up hearing matters. Yes.
May I permitted to mention one hearing matter, Lord?
You're hearing no. Call on the list.
It is
In item 1, Lordship, I'm for
Yes.
the petitioner. Your Lordship,
Yes.
I'm for the
Only-
appellant, my lord.
Yes, yes, mention. What is the matter?
Lordship, it has come at my instance,
Your
being
instance,
the
yes.
respondent, my lord.
Yes.
My lord, on 19th of December, the appeal was admitted, my lord, though the stay application has been kept pending. And my lord, affidavit have been exchanged. My lord, what has happened is direction was given for preparation of paper books to the appellant within 8 weeks. Now we have inquired that the lower court records have been received.
Certified copies of Exhibit 1 to 7 series are lying. Did you take back? Who was the
Take-
plaintiff?
My lord, I am the plaintiff, my lord, but as far as that is concerned, my lord, I don't have any instructions what certified copy. But my lord, why I am before my
No,
lord.
no. On scrutiny of the records, it is found that you had taken back. Your client plaintiff had taken back from the trial court with an undertaking to refile. Unless you refile, it will never be ready. So ask your client to refile the originals.
My lord, I shall. My lord, what I was humbly
Yes.
submitting and praying, my lord, or copies kahan hai iski? My lord, I am intending, my lord, subject to whatever falls from my lord, that whatever is to be done, we will do it, my lord. But paper books, my lord, since they were saddled with the responsibility to preparing the paper books within 8 weeks, my lord.
They.
Yes, my lord, the appellant. Now we want to take it on our shoulders so that we can expedite, and whatever nitty-gritties are to be worked out, my
Right.
lord, we'll work out, because my lord, this is a suit which is pending since 24 years, and after that,
You
I
are for the respondent here.
respondent, my lord.
My lord,
lord,
I appear for the appellant in
Why
this
didn't you
matter.
file the paper book?
My lord would kindly see the last order dated 19th of December 2024. My lord, the second page, paragraph 7, my lord. My lord, my lords have directed the trial court record shall be brought by special messenger at the cost of the appellant to be
No notice has been
deposited
served on
within
you.
the My lord,
No notice of.
my lord, we have deposited the cost of the special messenger, my lord. However,
Trial
no
court
notice
records
has
have
been
come.
received.
No notice has been served. That is what
Yes,
we
my
asked.
My lord, we are ready to file our paper books within
Yes,
8
then
weeks,
they'll
my
file.
lord.
My lord, we had given this letter to them.
Mr. Trivedi, since no notice has been served on them because the records are not complete due to your client.
I would have not.
Learned senior counsel appearing for the respondents, plaintiff stroke respondent submits that the respondents be permitted to prepare and file the requisite number of paper books, comma, since the appellant has not yet done so. Full stop. Learned counsel appearing for the appellant submits that since no notice of the arrival of the trial court records has been served on the learned advocate for the appellant, comma, the time to file paper books has not yet started. Full stop. Next para, we find from the office report dated February 17, 2025 that instead of the original exhibit numbers 1 to 7 series, comma, certified copies thereof are lying with the trial court records, since the plaintiff stroke respondents took back the originals in the trial court. Full stop. The plaintiff stroke respondents are directed to immediately file the originals of exhibit numbers 1 to 7 series, comma, latest within a week from date with the office to enable the office to complete the scrutiny of the trial court records and serve a notice thereof on the learned advocate for the appellant. Full stop. Since there is no fault on the part of the appellant in preparing the paper book late, comma, we retain the direction on the appellant to prepare and file the requisite number of paper books within the time stipulated earlier from the date of service of notice of the arrival of the trial court records on the learned advocate for the appellant.
Deeply obliged, my
My
lord.
point.
File those documents within a week, Mr. Trivedi. It's your fault.
Lordship. Lord,
I'm very deeply obliged, your lordship.
Thank you.
I bothered, my lord, because we had given them a letter, my lord. If they would
Your letter won't do. Your client has to file all the originals.
My lord,
Your client, the records are not ready.
I apologize.
my lords, another indulgence I'm seeking in can too, my lord. The affidavit and reply is ready. We would like to file it in court, my lord.
When the application
My
appears.
lord, opposition, no, my lord. If
My
they are
lord,
conscious,
Next,
take
next,
it
next,
on-
next.
Sir, unless the pleadings are completed, we won't be able to file the paper book, my lord. That is the only,
There's no difficulty in filing your paper book irrespective of the application.
my lord.
Yes.
The
Deeply
order states that Canto will appear together with the appeal, your lordship. So there is no problem. I will file that in the.
Very well. Then it's a fine. Yes.
deeply
I'm
obliged, my lord.
Yes.
I'm
Who is appearing for the appellant? Item 2.
My lord, praying for
Why aren't you responding? Yes.
my lord, praying for not today.
No. First matter, definitely not. We'll dismiss for default.
Advocate on record is not able to come to court.
Why?
He has an issue with his car, my lord. He is not able to come till now.
An adjournment is sought on behalf of the appellants. Full stop. Let the matter be adjourned till July 14, 2025.
Deeply
Next.
obliged.
Please give your name, sir. Whenever you appear, give your name. Yes.
Millard, we have served an affidavit in compliance with your lordship's order. The maintenance part, Millard, the quantum that was Millard admitted, we have given till date. Now, Millard, the one indulgence, Millard, I am seeking. Millard, the affidavit which I have served and affirmed, Millard, Millard, it is incomplete. Millard, two other informations are required to be made. 2 bank accounts were not included. I want to file it, Millard. I want to file an amended, Millard, affidavit.
So when do
Within a week, Millard, because accounts are not proper.
you have not yet filed your affidavits?
No, I have served, affirmed, served, not filed in the court.
So you want to file a supplementary affidavit or
Supplementary affidavit.
So
in
there
court.
are two applications.
Yes.
One is for implementation of the earlier order of maintenance. Other is for enhancement. As far the enhancement application is concerned, the pleadings are complete. As far as the implementation is concerned, there was a direction to file opposition that has not yet been filed. I am filing my reply.
no, let them file the opposition first.
No,
They're wanting-
reply in respect of the other application where opposition
Okay.
has been filed.
That opposition has been filed by them.
Filed by them.
It is filed in court. Court file anything?
Again, in file
Okay.
করলে
Oh, yes, that has been filed.
This is the the enhancement.
This is for the enhancement. Enhancement and also.
But I tell you,
You
lordship,
want to use a supplementary
Millard, I
affidavit.
tell you, lordship,
Suppose you want to use a supplementary affidavit to your opposition to the maintenance application.
yes, and Millard, it will lend assistance so far as the decision, Millard, adjudication of this list is concerned. Because if I
We'll take up both together. You file it within a week.
yes, give me 1 week time, Millard.
Yes.
So then
By
I'll
next
file an
Monday.
opposition to the supplementary as well. Supplementary affidavit,
You will.
my lord.
You have prepared your reply.
Lord, opposition I have not prepared.
Then you file one composite reply, including the opposition and as well as the
Lord, it is in respect of this application. And that is
this
the
application affidavit. This is complete.
complete,
regarding
but
the-
supplementary has been filed in respect of this application, this opposition.
Yes, that has been done because there were also, Millard, a defect.
So this will go on forever then.
No, Millard, as a last chance, Millard, I will file by a week, within a week.
No. You want to use a supplementary affidavit regarding this enhancement application.
Yes, because I tell
You
you,
file a composite reply to that. We'll give you 1 week from that.
But he didn't disclose my
Millard, affidavit in just for assets and liability, Millard, in consonance with Rajneesh versus
Yes.
Neha, Millard, the first part has been complied, but the second, Millard, as per direction, Millard, there is an error.
You want
I
to add that?
Yes. Otherwise, I will be
No, then it's a supplementary affidavit to affidavit to the affidavit of assets, not
affidavit
to
of
your
assets and
opposition.
liability. Affidavit
Not
of
to your
assets-
opposition.
No, affidavit in assets and liability.
Not a composite.
Your opposition is otherwise ready to
Yes.
that application.
Millard, the affidavits and assets and liability file করিনি।
Composite করে file করে
Millard, that the affidavit with supplementary affidavit that has been filed, it also contains
That has not been filed. You are wanting to file.
that is in respect of Millard, the enhancement. I am yet to file.
Oh, this also you have.
Filed and with a supplementary affidavit, both Millard, this contains certain errors. my lord, kindly permit me to file and
The affidavit in reply filed in connection with Can 4 of 2024 be kept on record. Full stop. Learned counsel appearing for the respondent husband seeks to use a supplementary affidavit to the affidavit of assets of the husband.
affidavit
Full
of-
stop. For such purpose, comma, the respondent is granted a week to affirm the said supplementary affidavit. Full stop. A copy thereof shall be served on the learned advocate for the appellant wife in the meantime. Full stop. Next para. On the prayer of the appellant wife, comma, the appellant wife is granted leave to file a rejoinder to the supplementary affidavit filed by the respondent husband in connection with Can 4 of 2025. Full stop. Such affidavit, such rejoinder shall also be filed within a week. Full stop. Composite affidavit in reply to the affidavit of assets as well as the supplementary affidavit shall be filed within a week thereafter. Full stop. Next para. Let the matter be listed. Let the applications be listed for hearing on July 21, 2025.
21 টা বললেন না।
Hmm?
21 কে আসবে?
21, my lord, instead of 21st, my lord, 22nd.
We will not be there from 21st to 1st because we will be going to Jalpaiguri. So if you want, we can keep after that also, 4th of August.
Yes, ma'am, after that.
হ্যাঁ, রিটার্নেবল ডেটটা 21st জুলাই না করে 4th of August করে দিন, August 4.
Yes, ma'am.
কি করে? হ্যাঁ, কি করে হলো এটা?
Maintainability of this application.
Why not maintainable, Mr. Paswal?
Because of the reason, my lord, he has filed a restoration application wherein admittedly the delay is 991 days. My lord, no separate section 5 application filed, no prayer has been made out in his application that delay may be condoned that of 991 days.
Substitution application has been allowed.
No.
Two application lordship is allowed. I think two is
Two
pending.
allowed, I'm not sure whether two are
What are
allowed.
pending now?
My lord, pursuant to my lord direction, I sent the copies or what?
Can 4 is substitution and Can 3 is restoration.
My lord.
Mr. Paswal,
Another substitution application is also pending. That was filed in 2018.
that was filed in time.
Yes.
And this Can 4 is in time.
No. Can 4 is also in time.
Not in time.
No,
When did he die? He or she?
died in 27th December 2017. Died on 27 December 2017.
Which paragraph?
But it is a resolution, my lord, in page 16. That you will find, my lord, extract from the resolution of the governing body meeting dated. That is later dated 23/3/20.
No, this is Can 4.
Yes, my lord.
Can 4 does not contain anything of that sort. Death of defendant number 5.
দিয়েছো?
সব কপি দেওয়া আছে।
আরে তুমি যা দিয়েছো এই তো আমার হাতেই।
হ্যাঁ, তো কি হলো?
Can 4,
Can 4, defendant number 5.
defendant number 5 died on 1st December 2020.
Yes.
And you filed the application in 2025. Where is the prayer for condonation of the delay?
No, in the code below, he has already been,
This arises from an injunction.
my lord.
If he has been added in the code below, Mr. Baswali will treat this as an addition of application. And let the applications be substitutions. What is the other substitution application?
Other substitution application regarding
Number?
two zero five six of 2018.
That I have. আরেকটা যেটা বললো সেটা নেই।
Attitude of service আর application একসঙ্গে বাঁধা কেন? 2056. বলা হয় নাকি? It is not showing as pending in the CIS.
Pending, not allowed. Because before that it was dismissed.
This was for on whose demise?
Paragraph 11, my lord, respondent number 2.
স্নেহময় বাসু না স্নেহময় বাসু তো কাটি না
No, no,
মধুময় বাসু
Mudhumay Basu.
আই তো
Snehomay Basu application in the lower court, it was not allowed. And
why
Sudhamay
not?
Basu is already on record. He had two brothers, Sudhamay and Snehomay.
I believe in the lower court, my lord, a point was taken with regard to this issue is with regard to a, my lord, a dispute of a society
Yes.
registered under Societies Act. Now a point was raised in the court below that it's a matter, it's a not a title suit that he has been substituted by his brother or his else so and so.
What was the nature of the suit?
Suit is, my lord, for declaration and injunction. Basically, my lord, to not to use the accounts of the this organization which is lying in court in College Street. That is the whole contention.
So
On
who was
that,
Mudhumay? Who was Mudhumay?
Mudhumay is one of the member of that committee.
So then how does
No,
That's what.
why should his heirs be
Yes,
included?
my lord.
yes, that's why it is not allowed. I am not pressing this. Application is pending and Sudhamay Basu already on record.
Very well. Can 2056 can 2 of 2018 within bracket old number can 2056 of 2018 is an application for substitution of the heirs and legal representatives of one Modhumoy Basu, comma, being the what is the respondent number?
2.
Being the respondent number 2 in the present appeal, full stop. Sudhamoy is on record or Snehomoy?
My lord. Sudhamay is on.
Sudhamay is on.
Full stop. It is submitted by learned counsel for the appellant that Sudhamoy Basu,
Respondent number 1.
comma, one of his heirs and legal representatives, comma, is already on record, full stop. Learned counsel appearing for the respondent submits that there is no question of impleading Snehomoy Basu, the other heir and legal representative of the deceased respondent number 2, comma, since the suit from which the appeal arises pertains to the disputes regarding a trust and the heirs of one of the deceased members need not be impleaded. Full stop. Such contention is not controverted in substance by learned counsel for the appellant. Full stop. Accordingly, can 2 of 2018 within bracket old number can 2056 of 2018 is allowed, comma, thereby recording the death is disposed of, comma, thereby recording the death of respondent number 2 Modhumoy Basu, full stop. Next para, can 3 of no, not can 3. Can 4 of 2025 2025
Present, can 2.
can 4 of 2025 is an application for substitution of defendant number respondent number 5.
Yes, my lord.
So what do you say to this? Where is
Same, my
the
lord, because the Nirjhar Kanti Bhattacharya is, my lord, one of the.
No, he is appearing for.
Oh, I don't
No.
know. No.
আপনি 5 এর করছেন তো?
Same submission may made regarding Espano 3A, my lord.
no
Espano 3A has been included, my lord. 3 was a member, my lord.
respondent number 5 Nirjhar Kanti Bhattacharya has died.
Died.
He was also a member.
Member.
So by same logic, why should his heir also be included?
That's why, my lord, I believe, my lord, all this document has been returned back because her wife definitely said, why I will take in all this because I know nothing about
So then
this.
we'll record the death of
Aparna Bhattacharya is already on record. Lower court allowed his substitution.
That I don't know.
She is already on record.
That I don't know.
very well.
5A is Aparna
So
Bhattacharya.
can 4 of 2025 is an application for recording the death of Nirjhar Kanti Bhattacharya, comma, the respondent number 5. Full stop. It is submitted that his wife, comma, being his heir and legal representative is already on record, comma, having been substituted in title suit number 35195 of 2014 from which the present appeal arises. Full stop. Accordingly, can 4 of 2025 is disposed of by recording the death of respondent number 5, defendant stroke respondent number 5, Nirjhar Kanti Bhattacharya, and impleading Srimati Aparna Bhattacharya, his Aparna Bhattacharya, comma, the widow of the late of the said deceased, comma, in view of the said Aparna Bhattacharya having already been impleaded as a party to the suit in the trial court.
By order dated
Yeah, whatever. First up, next para. The necessary consequential corrections shall be carried out by the learned advocate on record for the appellant in respect of both the applications during the course of the day. Now the difficult one for you.
My lord, regarding 3A, my lord, her name be expunged, my lord.
3A has also expired.
Yes, my lord.
Who is alive?
You want to
The
expunge?
trust is still running.
Bholanath Ghosh was the member, my lord.
We don't know Bholanath Ghosh,
Yes,
but
ma'am.
please.
He died, and his sister has been substituted, my lord. 3A is his
There is-
sister.
No.
He is not connected.
Here is on record. Bholanath.
Yes, here is health record.
This one of 3A, what is the name?
3A, my Maitri Ghosh.
She has died.
No. Our brother Bholanath Ghosh died, my lord, and he has been impleaded, my lord.
Respondent 3 is Bholanath Ghosh, not Maitri Ghosh. 3A is Maitri Ghosh is already on record in the appeal.
Yes.
We'll record his death also.
No,
When-
no, Maitri Ghosh not died. Alive.
He means Bholanath.
Yes.
Maitri cannot be he.
And Maitri Ghosh,
Maitri has to be she.
Maitri Ghosh has been recorded impleaded in this appeal, my lord. But he is not.
We'll record that Bholanath Ghosh. You have already stated here Bholanath Ghosh. In the appeal, it is stated Bholanath Ghosh since deceased and Maitri Ghosh has been. So why should he pass any order?
My lord, she is not a member of the association, my lord. She is not in any way connected to the association, my lord.
She has been made as a respondent.
Yes, unnecessary, my lord.
Argue that at the time of hearing of the appeal. Anyway, so can 3, what do you say? No application, no prayer for condemnation also?
No.
900 something days.
991 days.
The appeal itself has been dismissed.
Dismissed.
My lord.
So we'll retain that. That will be easier for everybody.
No, because blame was on erstwhile advocate. That's why my lord
Artful advocate, 891 days.
Yes.
What were your client doing?
no, the
Entire blame is on the erstwhile advocate. If
my
lordship
lord
sees this
directed me to
paragraph,
serve him, and I
he has
served
Serve
him
the
back.
erstwhile as-
he has not 4 years, my lord, this matter has been filed, and after 4 years it has been dismissed. During these 4 years, nothing has been spelled out in this application what he has done, and he is unnecessary blames advocate. Advocate is suffering from his family members are ill and all these things.
No, we are not satisfied with the cause.
Please
Para
see.
8 says
Yes,
he used to inquire about the matter either. The
my lord.
appellant states he used to either. Acha, he regular
And
interview.
lordship seen first, not in touch with the advocate, and then he says, my lord, otherwise. Kindly see paragraph 7 and paragraph 8.
It was dismissed during COVID time,
My lord.
No, in 2021,
19th August.
August 2021.
This advocate is still alive.
Yes,
Serve a notice on him.
served affidavit of service on record.
On Palas, this
Yes, yes.
person.
Yes,
These are the envelopes regarding the advocate.
no, others.
Others.
I served him by hand delivery. Affidavit of service filed earlier occasion. And presently, my lord, these affidavit of service we kept with the record on the last. my
What
lord,
is that regarding?
All applications. Most of them have come back.
Yes, but we don't find any reason. This. No.
If lordship seen the gaps, 4 months, 5 months, 6 months gaps, and he has filed.
This appeal is against an injunction application. Ad interim granted.
No,
Injunction application was disposed of.
disposed of and receiver appointed. I am challenging.
What
the
remains in that? After
receiver-
991, 891 days,
991 days.
they have stated in their prayer portion 891.
Yes, that is wrong. In their calculation, paragraph 10, page 20, lordship.
Yes,
kindly
not
see.
typing mistake.
Only 100 days. 991 days we won't count.
Lordship.
There is nothing
And
to
there-
show
and
that
there
you
is no
contact.
and there is no application for condonation of delay. And lordship will not find any prayer in his
All the
application.
All the annexes have been supplied. by-
Kindly see his prayer, wherefore you so and so humbly pray, please to restore the FMA application.
No, even if we hold that this is the prayer, that prayer is implicit because if we restore, you have to. But there is no explanation.
No, that's what.
No explanation at all. Nothing to show that you contacted your advocate at regular interval.
all the annexes have been supplied by the erstwhile advocate. Because of his ground, it has been dismissed.
It would be easier if you kept him.
Now, my lord,
What are these?
I can ask him.
These annexes, what are these?
These are all medical certificates.
Whose?
Erstwhile advocate,
Advocate.
my lord.
He suffered from corona during the corona period.
Yes. Thereafter, because of his wife, he took some time, and his office was fire broke out in his
Because of
office.
his wife, wife was.
now, my lord, one thing is
Yes,
that
there are other grounds also, Mr.
I've seen, my lord, I've seen.
Advocates ground.
But, my lord, kindly seen, my lord, paragraph 3, my lord, this suit was dismissed. Thereafter, in September, they have filed this. In 2017, they have filed this appeal. And appeal was dismissed in 2021. During 4 years, my lord, they have not taken any steps. And all of a sudden, they have come up and blamed the advocates and all these things, my lord. And if they have seen the gaps of this, sometime in, they said, my lord, COVID-19, that is in 2020, I admit that. But thereafter, they said they have not get in touch with the advocate. In next paragraph, they said, my lord, the learned clerk during regular interval assured that. Thereafter, they have himself searching that on 19th August 21,
My lord,
division
kindly
bench
come
has
to paragraph
dismissed.
12.
And see the gaps, my lord. Then 22nd September, he has obtained the certified copy and filed this appeal sometime in April 2024.
So, Bosumalik, para 11 and 12, the advocates, there were sufficient reasons for the advocate not to come. He might have missed the matter.
Yeah, I've seen.
Writ petition was
But these
filed.
are of 2023.
2023 and dismissed on 2021. An appeal filed in 2017.
What is the explanation from 2021 onwards for the advocate also? After you applied for certified copy and contacted him for restoration, then these problems came to him in 2023. So what happened between 2021, August 2021 and September 2022?
My client was kept in dark. He used to
Receiver was appointed and injunction
My lord,
granted.
he is appointed for receiver.
Yes, and receiver was appointed and receiver has been there for from 2017 until date, my lord.
Appeal is of 2018, nothing remains in the appeal. We'll request the trial court to decide the suit.
Yes, no. That's better, my lord. Because unnecessary, this matter has been
The
dragged.
present application for CAN 3 CAN 3 of 2024. The present application has been filed for restoration of the appeal. Push up next para. Learned counsel for the respondents points out that there is no prayer for condonation of delay, despite there being a delay of about 991 days in preferring the restoration application, even as per the calculation of the appellants. First up, next para, we find, upon hearing learned counsel for the parties and perusing the averments made in the application, that the matter, the appeal was dismissed on August 19, 2021. Full stop. Next para. In the said order, it was recorded that none had appeared for the appellant and the same situation had prevailed even on June 24, 2021, when it was recorded that none had appeared for the appellant and a notice be issued on the learned advocate enclosing a copy of the order. Full stop. Despite such notice, none appeared for the appellant on the relevant date when the matter was dismissed for default. Full stop. Thus, the negligence on the part of the appellants was evident even prior to the dismissal of the appeal for default. Full stop. In the explanation sought to be furnished in the present application, we find that despite the petitioners despite the appellant petitioner taking regular information from its erstwhile advocate and his clerk, it was assured that the matter was pending and nothing was informed about the dismissal for default. Push up. Accordingly, the appellant applied for certified copy of the necessary order on September 16, 2022. Push up. Explanation for the absence of the erstwhile advocate thereafter has been furnished. First of, however, we are not convinced from the averments made in the application as to what prevented the learned erstwhile advocate for the petitioner from conducting the matter diligently even prior to the dismissal for default as well as after the dismissal of default till September 2022 when the application for certified copy was made. Full stop. Next para. Moreover, comma, although a bare averment has been made in paragraph number 8 of the application that inquiries were being made by the appellant from its erstwhile advocate at regular intervals, comma, we find nothing on record to substantiate such allegation. Full stop. Since the appeal itself arises out of an order appointing a receiver and granting injunction, full stop, we find that in view of the huge delay of 991 days in preparing the restoration application, comma, the the considerations of equity are not in favor of the appellant stroke petitioner insofar as the condonation of the delay is concerned. Full stop. Hence, comma, even if we chose to gloss over GLOSS over the absence of a specific prayer for condonation of delay and deemed that the prayer for restoration included such prayer for condonation of delay, comma, even then we would be unable to condone the long delay of 991 days for the reasons as indicated above. Full stop. Accordingly, Can 3 of 2024 is dismissed on contest, comma, full stop. Since the appeal along with the connected pending applications have already been dismissed for default, comma, no further order need be passed in that regard. Urgent certificate.
Lordship may direct the, since it's a pending since the suit of 2014, my lord, if Lordship directs that.
It is due to the long pendency of the suit,
filed in 2014.
Comma, it is expected that the learned trial judge shall dispose of the suit as expeditiously as the business of the said court
Along with other miscases. Along with other
applications
permits, comma, along with the other pending interlocutory applications and miscellaneous cases pending in the trial court. Full stop. We hope and trust that the said suit and the connected applications shall be disposed of within an outer limit of 1 year from the date of communication of this order to the trial court.
Grateful. Mega.
And 2 is treated to be on the days list. Treated to be on the days list. Double. Yes. From the office, none appears at the time of call. From the office report dated July 4, 2025, comma, we find that there is a defect in the Vakalatnama filed on behalf of the respondent insofar as the name of the respondent is concerned. The learned advocate for the respondent is directed to rectify such defect by furnishing a proper Vakalatnama within a fortnight from date. Full stop. Let the matter be listed next in the monthly list of August 2025.
My lord, item 6, my lord, I beg to appear for the appellant, my lord. Pursuant to your lordship's kind direction, my lord, are served upon the respondents, my lord. This is my application for injunction. Your lordship,
I am appearing for the respondent. I would pray for a time for a fitting reply because I have been handed over the brief.
Use the microphone, please.
I would pray for
1 minute, please stand up straight. Why haven't you buttoned your coat? Is this the way to appear before a court of law?
I beg your apology, your lordship.
Yes.
I beg your apology.
How long are you practicing, sir?
I'm practicing since 2 years.
2 years and you don't know you have to button a coat before a court of law?
I beg your apology, your lordship.
Apologies won't do. Why shouldn't you refer your name to the Bar Council? Immediately.
I beg your
You don't know the minimum of the... Is it a drawing room?
beg your apology, your lordship. It won't happen again.
Lip service won't do, sir. Begging apology after you leave your buttons open and all, you appear before a court of law? Yes, use the microphone. What is your prayer?
Your Lordship, I have been handed over the brief yesterday by my client.
The court is not at fault for that. You took a brief yesterday, nor is he.
Not is my learned client, but I just want some time for a fitting.
Refused.
For a fitting reply to be filed.
Pardon?
For a fitting reply to be filed.
Fitting reply, unfitting reply, no reply. Learned counsel for the respondent seeks an adjournment for filing an affidavit in opposition to the injunction application. Well, Mr. Banerjee, you are granting that leave. He has a right. Footstep next para. Accordingly, the respondents are directed to file their affidavit in opposition to Can 1 of 2024. How soon?
In the month of August, by the month of
Within a week from date. Footstep reply, if any, shall be filed within a week thereafter. The matter shall be listed in the monthly list of August 2025. Affidavit of service filed to be kept on record. 1 week, it will appear in the monthly list of August. Next. Please give your appearance.
नाम लिखे दो
Recall application, restoration application, তাতেও নেই. It is unfortunate that Can 2 of 2025 is an application for restoration of the appeal on recalling an order dismissing it for default. Full stop. We find that by the relevant order dated April 21, 2025, we had recorded that it was the third occasion when none appeared for either of the parties at the time of call, upon which Can 1 of 2023 had been dismissed for default. এই প্রথমে যেটা বলেছি restoration of the appeal for default or restoration of the application. So next para, even today, at the time of call, the appellant does not have the courtesy to appear and move the recall restoration application. Full stop. Hence, we find that the appellant is a habitual defaulter, and as such, Can 2 of 2025 is dismissed for default. Full stop. Consequentially, the order dated April 21, 2025, whereby Can 1 of 2023 had been dismissed for default is sustained. Full stop. Next para, the appellant shall prepare and file the requisite number of paper books as per our earlier direction, as and when the appellant's advocate is served with a notice of arrival of the trial court records. Yes.
And for the appellant, Lordship.
Yes.
There is an application, Lordship, for Section 5. Condonation of delay of 448 days, Lordship.
148?
448.
In your caption, you have...
I saw that, Lordship. It is 400.
You have corrected and written 148.
4 has
caption
been...
and the prayer.
4 has been written as 1, Lordship.
4 has been connected, erased, and written as...
Lordship will kindly take up the prayer.
Eta din onake. See the prayer also. Please see the prayer also.
এখানে 4টাকে
So
এটা withdraw করে my lord, may I
what is the explanation for the delay?
Explanation is not very sound.
No explanation.
Explanation is there, one paragraph explanation, Lordship.
Where is that paragraph?
Paragraph 13 and 14, Lordship.
Delay in filing the appeal?
Yes. The petitioner, the appellant petitioner lordship is suffering from terminal illness. That is why
She is appearing for the first time.
appearing for the.
Leave on the prayer of learned advocate for the appellant, leave is granted to the said learned advocate to carry out the necessary rectifications regarding the span of delay in the cause title as well as the prayer portion of the application during the course of the day. A corrected copy of the application the name of the respondent is not written in the caption in the cause title. Who has drafted this?
In the cause title
of the application?
It is there, lordship, page 2.
Sorry, it's our mistake. Copies hobe ota. Copies of the corrected application shall be served on the respondents at the earliest, and an affidavit of service to that effect shall be filed on the returnable date. The application shall be listed under the appropriate heading in the monthly list of August 2025.
I'm very grateful.
We carry out the corrections immediately.
Corrected with the leave of the
9, yes.
Honorable Court.
35, who is for the appeal?
I am for the respondent.
You have not filed the certified copy of the decree? What is the appeal against? Why are you here? You're smiling and laughing. You move your application, ma'am.
Kindly given a short pass over, Lordship.
Why?
Senior is on the way, Lordship.
Who is on the way?
And senior.
Please use your microphone. Who is your senior?
Given a short pass over, Lordship.
Who is your senior?
Tapan Dattu Gupta.
Pardon?
Tapan Dattu Gupta.
What is the application for?
My lord, this is an appeal, my lord, against, my lord, section 22, restitution of conjugal right, my lord.
Special manager.
Yes, my lord. And what has happened, my lord? The husband, my lord, got the, my lord, the order, my lord, for restitution, my lord. Against that, my lord, they have come before this court. And they wanted, my lord, this is an application for stay of that impugned order.
Unless they get and stay and you execute it, they'll be in difficulty. So, you'll grant
But
that
in the
stay.
meantime, my lord, what has happened, my lord? The husband has, my lord, filed a divorce application, my lord. Because, my
So
lord,
then you also ask for stay.
my lord, what has
So
happened?
joint prayer, will make it a joint prayer then.
My lord, what has happened, my lord? The wife left the husband in the year 2018. Thereafter, my lord, the husband has preferred a matrimonial suit, my lord, before the Barubir court for divorce. And in that particular suit, my lord, the court has passed an order because no effort has been made by the husband to get back the wife. So that's why the suit got dismissed. My lord, thereafter, my lord, what has happened, my lord? Several intimations, several emails, several WhatsApp messages has given by the husband to the wife to come back, my lord. But lord, there is no response from the wife. And thereafter, in the year 2022, my lord, the mother of the husband died. And thereafter, my lord, again intimated to the wife. And the wife in the WhatsApp has written rest in peace. And thereafter, no communication. Thereafter, no communication by the wife to the husband. And thereafter, my lord, the husband again
Rest in peace in full form, not RIP.
It's on full form, my lord. What I got to know from my client that the wife has gone to London, my lord, after 2018, and she is staying in London. And the appeal, my lord, which has been filed by them, my lord, has been affirmed by one third
London
party.
and Mednipur do not tell you.
Yes,
Their
my lord.
address is given in Mednipur.
Yes, my lord. Well, I got from the information from the client, my lord, and the affidavit which has been affirmed in this application, my lord, has been affirmed by one third party, my lord. I don't know who is he.
Agent.
Yes, my lord.
But what remains in the, I mean, you should concede to the allowing of the appeal. If you have filed a divorce suit, we'll take note of that.
Yes,
And
my lord. And what is happening, my lord, on that particular
do
divorce?
you want this restitution anymore?
No, my lord, they are not coming back. She is not coming back, my lord.
So suppose your divorce suit is dismissed. Even then, since you have filed that divorce proceeding itself, I mean, you have given up your restitution.
Yes, my lord.
So should you dispose of the appeal itself along with the application? will take note of judicial note of the fact that you have subsequently filed a
Yes.
divorce suit
Yes, my lord.
and dispose of the
And my
appeal.
lord, they are not willing to come back, my, so that's why, my lord, they have come with this appeal, my lord. They are telling that they will not come back, my lord. If
Obvious.
that observation, if my lord may be given, in that could.
So the filing of this appeal itself means that they don't want
Yes,
to come
my,
back.
yes, my. If that observation may be given, then we will be helping in the divorce with my lord.
You are allowing your appeal.
No,
Allowing your appeal.
sorry, sorry.
Yes. She says no, you say yes.
No, sir, he's not my senior.
Now you're saying no, she's saying yes.
Senior, my senior is on the way, Mr. Tapan Dattagupta.
Learned counsel for the respondent husband submits that subsequent to the passing of the impugned decree of restitution of conjugal rights passed in favor of the respondent husband, comma, the respondent himself has initiated a suit for divorce. That suit was dismissed.
My lord, the first suit was dismissed.
Second suit you have filed.
Yes, my lord. It is pending and it is for them to file the written statement.
How could a second suit be maintainable?
My lord, because my lord, at that point of time when it was been filed, my lord, it was observed by the court that the proper effort has not been taken by the husband to bring back the wife.
So you put in subsequent
Yeah,
cause of action.
I've given my evidence there in the restitution. file.
The husband filed a suit for divorce. Full stop. The first such suit for divorce was dismissed primarily on the ground that the husband has not taken sufficient efforts to bring back the wife. Full stop. Next para, learned counsel for the respondent submits that thereafter, comma, the husband wrote repeatedly to the wife by several modes, but the wife is not willing to come back, and the husband is informed that the wife is now staying in the United Kingdom. Full stop. Next para. From the very fact of filing of the present appeal, comma, it is evident that the appellant wife is also dissatisfied with the decree of restitution of conjugal rights. Full stop. Next para. Accordingly, comma, no useful purpose would be served in keeping the appeal pending, comma, since both the parties, since not only is the appellant challenging the decree for restitution of conjugal rights, comma, the husband has himself filed a second suit for divorce, which is now pending, comma, thereby clearly expressing his intention not to proceed further with the execution of the decree for restitution of conjugal rights. Full stop. Next para. We are of the opinion that it is a futile exercise to keep both the parties captive in legal rigmarole unnecessarily. Full stop. Hence, comma, in view of the above observations, comma, we decide to take up the appeal along with the application. Full stop. Since a subsequent second divorce suit has been filed by the husband, comma, it is evident that the animus revertandi is no longer existence in the perception of the respondent husband as well, comma, thereby denuding the very basis of the decree for restitution of conjugal rights. Full stop. We take judicial note of such subsequent divorce suit by the husband. Full stop. Accordingly, FAT 355 of 2024 is allowed, comma, allowed on consent. Should we make it? Is allowed, we are making.
Is allowed.
Allowed, comma, thereby setting aside the impugned judgment and decree dated August 20, 2024, passed by the learned additional district judge, fast track court at Baripur district, South 24 Parganas, in matrimonial suit number 83 of 2023, and dismissing the said matrimonial suit for restitution of conjugal rights. Full stop. There will be no order as to cost. Consequentially, can 1 of 2024 stands disposed of as well. Full stop. In view of the above order, comma, we waive the requirement of filing any certified copy of the impugned decree further. না লাস্ট লাইনটা কেটে দিন ইউ উইল ফাইল আ সার্টিফাইড কপি অফ দি ডিগ্রি প্লিজ ফাইল আ সার্টিফাইড কপি অফ দি ডিগ্রি আদারওয়াইজ দিস ডিগ্রি ক্যানট বি drawn up. The appellant shall file a certified copy of the impugned decree within a fortnight from date. Full stop. A formal decree be drawn up accordingly.
OCP is my senior.
Restitution allow করেছে আমরা সেটা সেট করলাম করে সুটটাকে ডিসমিস করলাম.
My lord, I am very sorry, my lord. Item number 7, my lord, I could not.
It was vehemently opposed by the appellant that we are allowing the appeal.
Yes, my lord. Let my name be.
Grateful accept.
Which matter? You are in
7, my lord. Item number 7.
7. We have passed some order.
7, my
We
lord.
cannot turn the clock back. Whatever order we have passed, it's there.
No, my lord, if it is dismissed for default, my lord, kindly make it not today, my lord. Kindly make it not today, my lord.
No, we have dismissed for default.
No, my lord, kindly.
No, we have recorded your conduct. No.
My lord,
You have to
once-
file another application. Now we'll dismiss that.
that building, my lord.
Should have put someone. No.
My lord, I could, my lord, if you lost it, my lord.
No. Call on the next.
Ten, I appear for the respondent number 12.
Yes.
Already, your lordship at last passed an order 26th of June, where your lordship directed affidavits to be exchanged. The time for affidavits has not yet expired. Possibly what has happened if your lordship sees the order para 7,
Oh,
your lordship said monthly of July. It possibly ought to have been August.
Affidavit time is expiring on
That's why it's
24th of
appearing
July.
yes.
26th of
So
July.
we'll keep it in the monthly list of August.
August.
All of you. Yes.
Grateful, Your Lordship.
Leonard, it is submitted on behalf of the parties that in the order dated June 26, 2025, we had directed affidavits to be filed, which however, the returnable date was erroneously fixed prior to the expiry of the time for filing affidavits. Full stop, next para. Taking note of such submission and agreeing with the correctness of the same, let the matter stand adjourned and be listed under the same heading in the monthly list of August 2025.
The appeal and all the applications.
All the applications, madam.
Let the appeal along with the applications be listed
Right.
in the monthly list of August 20.
Grateful.
Thank you.
Grateful.
That is, my lord, I just, my lord, I am appealing for the appellant petitioner.
What is the defect, Mr. Rai?
That is regarding set down, subject to question, my lord.
Let us check up.
And
Several-
service, my lord, service not yet been.
68 days delay.
Yes, sir.
Section 5 is there.
That is there.
Achha, 1. Respondent number 13 of memo of appeal differs from defendant number 13 in certified copy.
Yes.
So should you correct the
It should be recorded because the memo is correct. So in the degree itself, there is typographical error.
Achha.
B as it, my lord, the service, there is a direction for service. The service not yet been completed. That is why.
completed? Service of the section 5
Yes,
not yet completed.
Not yet completed, my lord.
We'll put in some finding regarding the defects also.
Thank you, lordship. Jesus.
We find that several defects have been pointed out in the appeal by the stamp reporter. Full stop. Next para, insofar as the name of respondent number 13 is concerned, learned counsel for the appellant submits that the name given in the memorandum of appeal is correct, whereas that appearing as defendant number 13 in the certified copy of the impugned order.
It cannot be ordered, my lord, because
How can the name be?
counterclaim allowed.
Impugned decree
Yes,
is
suit for partition.
very well. Impugned decree is incorrect. Full stop. Insofar as the other defects are concerned, since an application for condonation of delay has been filed, and the impugned degree bears a wrong date, which is to be rectified by the trial court, the said defects are in order to correct the said defects, the file is to be sent down for rectification. Full stop. However, since learned counsel for the appellant submits that the service of the application for condonation of delay is not yet complete, we adjourn the matter for a week.
For a week.
For such purpose, full stop. Accordingly, let the applications be listed next on July 14, 2025.
But I'm for the appellant.
Yes.
Let the affidavit complete. Let the affidavit of service.
Good service.
I have not.
No,
I've been told that it has.
একজন শুধু ফেরত এসছে অ্যাড্রেস আইটেম ডেলিভারি শুধু প্রশান্ত ঘোষ ফেরত আছে প্রশান্ত ঘোষ হচ্ছে
প্রশান্ত ঘোষটা ছিল
ডি রেসপন্ডেন্ট নাম্বার 2D
My mother-in-law, my lord.
No, service affected.
Yes, my lord, service affected. Only, my lord, defendant number 2D, Sushanto, it has came back with the remark, address cannot be located, but my lord, they are, my lord, defendant number 2 series is, my lord, the promoter. So others have been served.
You are seeking injunction against everybody.
Everyone, yes, yes.
2C has not been served properly.
2D, my lord, 2D. Because my lord, AT Enterprise is being represented by other partners.
They appeared in the court below during hearing of the injunction application. 2D.
No, my lord. It's only the defendant number 1 and 3 who contested.
The affidavit of service filed to be kept on record. Full stop. It transpires that only the defendants stroke respondent numbers 1 and 3 contested in the trial court. Full stop. Apart from respondent number 2 small d, the others have been satisfactorily served. Full stop. Since the defendant stroke respondent number 2D had not contested in the court below, we dispense with further service on the said respondent. Full stop. The injunction application is taken up for hearing ex parte, since none appears despite service to contest the same. Full stop. We find from our order dated June 9, 2025 that upon elaborate reasons being given, we had granted ad interim injunction. Full stop. We had observed, as we also find now, that the plaintiff stroke appellants have made out a strong prima facie case inasmuch as despite the property originally belonging to the father-in-law of the appellant number 1, the same was transferred by the mother-in-law, by her mother-in-law in favor of the defendant's respondents, which according to the appellants did not confer title on the defendants. First of that apart, the plaintiff stroke appellant number 1, by virtue of her claim through her deceased husband, ' estate, has a right of residence in the suit property, which is a part of such estate. Full stop. Accordingly, IA number CAN 1 of 2025 is allowed ex parte, thereby granting injunction restraining the defendants, respondents, and or their men and agents from interfering with the peaceful possession of the plaintiff's appellants in respect of the suit property in any manner without due process of law till disposal of the appeal. First of the appellants shall put in due requisites and postal costs for service of notice of the appeal on the respondents within a week from date. You have the papers.
Yes, my lord.
In view of the appellants being equipped with all the necessary papers, we dispense with calling for the trial court records for the time being. Full stop. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks.
My lord.
Within 6 weeks from date, first of liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
I'm ready.
My lord, I appear for the appellant, my lord. My directions were passed, my lord. But affidavit of service is being affirmed, my lord.
Has been served.
Has been served, my lord.
Can you file during the course of the day?
My lord, only thing, my lord, I want to file a supplementary affidavit, my lord, bringing the current state of affairs so far as the affidavit of assets are concerned, my lord. Affidavits were assets were filed, my lord, during the course of the proceedings in the trial court, my lord. Now the situation has changed, my lord. I need to
Your affidavit of assets.
My lord.
Right. Learned counsel for the appellant submits that although a copy of the application has been duly served on the respondent, comma, the affidavit of service is in the process of being affirmed, full stop. Leave is granted to the appellant to file the affidavit of service during the course of the day. Full stop. Next para. Learned counsel for the appellant seeks to file an affidavit of asset. You have already filed an affidavit of file an
It was
affidavit.
filed before the court below. Now
File an
fresh.
affidavit of assets reflecting the current state of affairs. Full stop. Accordingly, leave is granted to the appellant to file her affidavit of current affidavit of assets within a fortnight. Within a fortnight from date, full stop, the appellant shall serve a copy thereof on the respondent and file a further affidavit of service on the returnable date. Full stop. Reply, if any, shall be filed. Now, affidavit in opposition, if any, to the composite opposition, composite affidavit in opposition, comma, if any, shall be filed to the alimony application as well as the affidavit of assets of the wife by the respondent husband within August 11, 2025. Full stop. Composite reply, comma, if any, thereto shall be filed within August 18, 2025. Full stop. The application shall next be listed for hearing on August 20, 2025. You file this affidavit of service during the course of the day.
In my
Yes,
instance,
sir.
this is my appeal from refusal of an ex parte order of injunction in a defamation suit. Your lordships have passed the order on 16th of June 2025.
Yes.
There is an injunction we were directed to serve and come back. No? We've served, he's received. No, this is the gentleman who writes to BBC about Exide. Your lordship would recall and sends blood-stained letters
Yes,
to me. I've served him. Unlikely he's going to appear, my lord.
So let him suffer injunction till disposal of the appeal. What can be? Affidavit of service filed today be kept on record. Full stop. Next para. None appears despite service for the respondent. Full stop. We find from our ad interim order dated June 16, 2025 that the matter was considered at length. Full stop. We had observed in the said order, comma, as we do now as well on the basis of the materials on record, comma, that from the annexures to the present application, which are also a part of the trial court records, comma, the allegations made by the appellant, the allegations made by the respondent against the appellant are palpably unacceptable and not confined merely to usurpation of the patented technology of the respondent, but border on the defamatory. Full stop. Next para. Accordingly, IA number CAN 1 of 2025 is allowed ex parte, comma, thereby granting an injunction restraining the defendant stroke opposite party from respondent opposite party and or his men and agents from threatening, comma, publishing or circulating any article or issue any statement to the appellant and stroke or to any third party, comma, either through emails, comma, social media or through any other media whatsoever, comma, containing words similar to the ones used in the letters and communications annexed at annexed as Annexure G to the plaint filed in title suit number 639 of 2025, as well as any other communication having the purport or effect as mentioned above or designed to injure the business and goodwill of the appellant and stroke or any other threatening communication in any manner whatsoever having the effect of defaming and interfering with the business and regular affairs of the appellant company, comma, till disposal of the appeal. Full stop. You are equipped with the papers, all
Yes,
the
Lord.
papers? Very well. In view of the appellant being equipped with the relevant papers, comma, calling for the trial court records is dispensed with. Full stop. The appellant shall put in postal costs and due requisites for service of notice of the appeal on the respondent within a week from date. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from date. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Very good.
Appellant.
Then petition. A final decree, in a partition suit, that has been challenged, the commissioner's report has been accepted, and finally.
You have not filed a certified copy of the decree. And classification is also wrong. They are saying, what is the classification? This is against what? A decree?
Final decree.
You have, in your memorandum, you have to correct. You have stated from order. Caption. So from
Lordship kindly grants me a leave, my lord. I'll.
we will give that leave. And what about the filing of the decree, Mr. Vanis?
Lord, I'll take it. Kindly.
What is the application for?
Application, my lord, is for my lord injunction, so that my lord final decree has already been drawn up. My lord, in respect of my lord the report filed by the commissioner, so that my lord no third party interest is created. My lord, the nature and character be not changed. That is my application.
Where will you file the certificate copy within a fortnight?
Yes.
The present application. Now, tar aage, leave is granted to the learned advocate on record for the appellant to carry out the necessary rectification in the classification of the appeal as an appeal from appellate from original decree. Full stop. Such correction shall be carried out during the course of the day. Full stop. The appellant shall also file a certified copy of the trial court's decree within a fortnight from date. Full stop. Next para. The present appeal arises against a final degree of partition. Final degree of partition. Full stop. Upon going through the materials before us, comma, we are satisfied that a prima facie case for hearing of the appeal on merits has been made out, comma, both on facts and on law. Full stop. Accordingly, the respondent and or his men and agents is restrained by an order of injunction from from changing the nature and character of the suit property in any manner and or from creating any third party interest in respect of the suit property during pendency of the application. Full stop. Execution, they have not levied execution as yet.
Yet, well, proposed execution.
Full stop. The respondent shall also remain stayed from levying execution in respect of the impugned decree till disposal of the application. Full stop. The appellant shall serve a copy of the application on the respondent at the earliest, indicating that the application shall next be listed for hearing in the monthly list of August 2025. Full stop. The appellant shall file an affidavit of service on the returnable date. File your certified copy within a fortnight, decree and correction immediately.
Correction by tomorrow. My lord, because my lord, my advocate on record is Mr. Maiti.
Such correction shall be carried out during the course of the day, bolam jeta? By tomorrow.
Wait.
Correction shall be carried out by tomorrow. Positively do it.
Yes, certainly.
Yes.
My appeal.
Yes.
This pursuant to my lord's last order of 17 June, I was supposed to serve my lord, the respondent number 6 and 7. 1 to 5 were earlier served.
Yes.
Now, my lord, I attempted to serve, my lord, the order was, my lord, that I should locate the advocate on record in the trial court. But we found out, my lord, but the lady, my lord, has passed away 4 years ago. So we attempted to find the address on the website, my lord. We have found the address on the internet, my lord. We have served. It has been duly served.
But
So 4 and 5 and 6 have now been served, but not at the address mentioned in the cause title of the suit, but otherwise, my lord, they have been served. This is the situation, my lord.
but you'll have to then correct the cause title in the memo as well as the application also.
We'll do that, my lord. Kindly provide leave, my lord. We'll do it in course of that.
We had granted ad interim order.
Yes, this was a suit for my lord, declaration. We were enjoying an interim order throughout the suit. The defendants entered a period, filed a written statement, then did not contest the suit. But ultimately, at the final hearing, the suit was dismissed, my lord. Then, my lord,
So you are enjoying an ad interim.
I am till the disposal of the appeal, my lord.
We'll file the certificate. Sorry, the affidavit of service. Affidavits of service filed today be kept on record. Full stop. It transpires therefrom that the respondent number 6 and 7, who were previously unserved, have been served at their current address, which has since been identified by the appellants. Full stop. Leave is granted to the learned advocate on record for the appellants to carry out the necessary correction in the cause title of the memorandum of appeal as well as the application during the course of the day, incorporating the current address of the respondent number 6 and 7. Full stop. Next para. Since despite service none appears for the respondents at the time of call, we take up the application for hearing ex parte. Full stop. In view of a sufficient prima facie case having been made out, full stop, IA number can 1 of 2025 is allowed ex parte, no, you had got injunction.
My lord, yes, my lord.
Allowed ex parte, thereby restraining the respondents' opposite parties and their men and agents from disturbing the peaceful possession of the plaintiff's appellants in respect of the suit property in any manner whatsoever till disposal of the appeal. The appellants shall put in postal costs and due requisites for service of notice of the appeal on the respondents within a week from date. The trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within a week. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. First up, liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you.
I'm deeply obliged.
But that correction is very crucial during the course of it.
Immediately, my lord.
In the memo as well as the appeal.
Yes, my lord.
Lordship, I appear for the respondents. My
Respondent.
Today, my lord, I will be praying for an indulgence, my lord. Only today I have received a brief in the morning. If your lordship will kindly Lordship,
Take the affidavit of service so that the names can be recorded, and we'll take it up when? Tomorrow?
Tomorrow or on Thursday. My Thursday.
Thursday we could take up appeal hearings. So we'll keep it
next week.
next week. Very
31st, the date has been given by
next week, any day, Lordship.
Very,
Subject
very
to Lordship.
affidavit of service filed today be kept on record. Full stop. Learned counsel appearing for the respondents. All the respondents.
Respondent number 1. Dekhi.
He is the only contesting respondent.
For the respondent number 1 seeks an accommodation. Full stop. Accordingly, let the matter stand adjourned till July 14, 2025, when it will be listed under the same heading. Mr. Bhattacharya, you have served on all the respondents.
1 and 3 has been received. 1 and 2 has received. 3 has not been returned, my lord. Service returned.
This is against what?
Petition suit.
No, injunction.
Injunction, my lord. Injunction.
By opposite party number 1 only.
Ad interim injunction.
Ad interim injunction, my lord.
An interim injunction of status quo was there. Thereafter,
Then Mr. Bhattacharya, you have to serve on respondent number 3 as well. Because at this stage we cannot say they did not contest. Fresh service.
Returnable date, my lord, we shall see that 3 is.
The learned the Arakta line add kori, the appellant shall, in the meantime, effect fresh service on the unserved respondent number 3 and file a supplementary affidavit of service on the returnable date.
I'm grateful.
Thank you.
My lord, I appear on behalf of the appellant.
Yes.
My lord, I beg to appear for the respondent, my lord.
Here, my affidavit.
I want to.
You are for all the respondents?
All the respondents. My lord,
Here,
I
my affidavit,
want
sir.
to file an affidavit in opposition, my lord.
What is the application for?
My lord, this is
My
my
lord,
lord-
this appeal is from refusal to pass ad interim order, my lord, of injunction.
So you'll be happy if they want to use an opposition. You are enjoying it.
my lord,
How soon?
2 weeks, my lord. My lord, only, my lord, I beseech, my lord, a date may be fixed so that, my lord, the matter can be taken up, my lord.
Yes, yes, we'll fix a date. Not fix the matter as such, a returnable date will be fixed. Learned counsel appearing for the respondents seeks an opportunity to use an affidavit in opposition to the application. Whosoever accordingly, the respondents are directed to file their affidavit in opposition by July 21, 2025. Whosoever reply, if any, shall be filed by July 28, 2025. The application shall next be listed for hearing on August 5, 2025.
Grateful.
Yes, Mr. Banerjee, do you oppose the prayer? Yes. This morning a prayer was we expressed our intention to allow the appeal.
Opposing a prayer for withdrawing, my lord, an appeal for 1 hour and 15 minutes.
Where?
For my lord, just
This was happening.
Tapobrata Chakraborty's division bench.
No, in the
appellant was caught, my lord, saying wrong statements on oath. After
No, in
3
the
days
morning we faced something more interesting. We gave an offer that we shall allow the appeal along with the application. Respondent agreed, but the appellant opposed. But ultimately, good sense prevailed.
Excuse me, excuse me,
Yes.
excuse me.
None appears for the parties at the time of call. Full stop. Let the matter stand adjourned and be listed in the monthly list of August 2025. Yes.
23, Lord, I appear for the petitioner, my lord.
I beg to appear for the alleged contempt.
This is my application for contempt. Lord,
What is the nature of contempt alleged by you?
my lord, this was a direction passed by my lords regarding payment of alimony pendently, not along with arrears. Arrears were pending since September. That arrears were supposed to be paid in 2 installments. First installment by 15th of April, second installment by 15th of May. And along with that, there was a specific direction of payment of cost of the litigation. Now the entire amount was not paid. What they do is they subsequently go to the Honorable Supreme Court, challenge that order. They could not secure a stay order there.
That challenge is pending.
The challenge is pending. The SLP is neither admitted nor SLP has been disposed of. But there was a direction by the Honorable Supreme Court to pay the arrears first and then come back with the SLP. They have even not complied to that order also. Now,
File a contempt before the Supreme Court.
now what they have done is they have served as an advance copy of an extension application for depositing the arrears in the Supreme Court. With the Honorable Supreme Court. I'll indicate that to my lord.
But then you are in contempt of this order.
My lord, this is just a minute.
Let him finish this. Sorry.
Well, this is my supplementary affidavit where I have annexed the order of the Honorable Supreme Court. Page 9, my lord, will find the order.
Yes, what do you say?
My lord, I just want to canvass the crux of the matter. My lord, on 2nd of April, this honorable court passed the order. And after that, my lord, I never challenged order of this court. I was arranging money, my lord. And while I was having problem to arrange money, I just prayed an application for bit extension to the Supreme Court.
Unless you challenge this order, how could you make that payable before the Supreme?
In my prayer, I didn't specifically mention that I am not going to pay or I am going to pay this.
Unless you prefer a challenge, there is no SLP in the eye of law.
My lord,
SLP means you must have challenged the order.
My lord, what I am trying to say.
But the basis of that was that you want some time to.
My lord.
So that was granted to you by the Supreme Court. You have to pay first.
My lord, what I was trying to say that I need some time. I will pay each and every penny, but I need some time because I am.
You have not even paid 1 penny. How can you be sure that you will be?
My lord, what is my conduct? My lord,
no, let him finish.
My lord, in the meantime, what was my conduct? I have paid 7,45,000 and I am paying 60,000 in every month. So it's not that, my lord, I am not
paying, I'm shying away. It's not that. I'm paying, but my lord, since it is a huge amount, I am having some problem. My lord,
how long will you take to clear the entire amount?
My lord, I don't have any specific instruction regarding the time.
Then
but
how can you be sure that you will be doing it?
My
You
lord,
have to be sure
will
of your bona fides.
my lord, direct me 3 or 4 months. Within that, I will pay.
Mr. Chatterjee, what is the, what is the due as per you?
My lord,
Now, as
I
of now?
made a calculation, my lord, and it takes up my supplementary affidavit.
No,
Lord,
you have,
page 5
you
is
have,
the due of
you have deducted the amounts paid by him in the meantime.
Yes, my lord. Well, can you take up page 5?
5 years.
Yes, my lord. There is a tabulation given. Well, monthly alimony starting from month of April to June.
What is the reflection of the deductions?
Yes, but deductions have been one-time ad hoc litigation. Well, amount received on 9th June 2025, 7,45,000 is the deduction.
Achha,
And
yes.
as on date, 27,55,000 is due.
Give us a timeline. How do you propose to clear the and current alimony they are paying?
My lord, they are not even paying the current alimony.
Nothing.
Nothing.
My lord, I am paying 60,000, which was the earlier order upon me.
What was the alimony directed by this court?
My lord, kindly takes up page 63 of the.
What was the alimony directed by this court?
My lord, it is something 3,60,000 around. My
Lord,
lord,
3,60,000 per month, deducting 60,000 as he is already paying by way of the order of the DVAT case.
Can you excuse me just once, my lord? I'm
Yes.
sorry, my lord, my video
No,
is not
non-difficult.
working. My lord,
What was the
Supreme
total
Court
amount
has
directed by us?
3,60,000.
All right.
3,60,000.
Very well, very well. 60,000 was directed.
And today,
125. 60,000?
yes, in a domestic violence proceeding.
This was the earlier order, my lord.
So page
No, you are paying 60,000 per month means you are complying with the order of the 125 court. You are grossly flouting 3 lakh.
No, my lord.
No.
My lord, I have paid 7,45,000, and that's why, my lord, I went before Supreme Court with folded hands that I need some time. My lord, for contempt, there must be some willful and deliberate violation.
You are directed to pay the entire arrears within 4 weeks from that date by the Supreme Court.
That is my only prayer, my lord, before the Supreme Court, that I need some time. I will pay.
Period has elapsed, sir.
My lord, no, my lord. Within time, I went.
Please come to page 9 of the supplemented affidavit.
My lord, I didn't receive any copy.
Why didn't you give a copy?
Receive any copy,
Lord,
my
there was
lord.
no reaction for service, but I've given them notice of
It's an order on his matter.
Very well. You come prepared on the copies. The a prima facie case of contempt has been made out. Full stop. Accordingly, Arakta line on the prayer of the petitioner, leave is granted to the petitioner to file a supplemented affidavit, which is filed today and kept on record. Full stop. Copies thereof
I'm serving it today, sir.
are being served here and now on the learned advocate for the
As well as the contempt application.
respondent. Full stop. Next para.
The order detection, order.
Learned counsel for the it is submitted by learned senior advocate appearing for the appellant. Mr. Chatterjee is appearing with you in this.
My lord, he's
Senior advocate for the appellant that in gross violation of the order of this court,
My lord,
the total alimony as directed by this court to be paid per month to the tune of rupees 3,60,000 is not being paid by the respondent husband by the alleged contemner. Puts up next para. A chart in that regard has been given in paragraph 4 of the supplementary affidavit, which indicates that out of the total arrears, only an amount of rupees 7,45,000 has been paid, leaving an amount of rupees 27,55,000 due in lieu of arrears of alimony. Full stop. It is further submitted that current alimony is also not being paid in terms of the order of this court. Full stop. In the meantime, the alleged contemner has preferred a special leave petition against the order of this court, which is under contempt. Full stop. In the said special leave petition, no stay has been granted. Full stop. Rather, by an order dated May 13, 2025, the Honorable Supreme Court directed the arrears of alimony to be paid first by the petitioner within 4 weeks from that date. Full stop. By now, the said outer limit of 4 weeks granted by the Supreme Court is also over. Full stop. Next para. Learned counsel for the alleged contemner submits that the alleged contemner has preferred the special leave petition primarily to seek uh, further time for clearing of the arrears of alimony. Full stop. It is further submitted that the alleged contemner is attempting his very best to clear off all the arrear amounts as early as possible and is paying rupees 60,000 per month in lieu of alimony to the petitioner.
And my lord, in the meantime, I have paid 7,45,000 as well.
Full stop. Next para. In the meantime, comma, it is submitted, comma, rupees 7,45,000 has also been paid, which in any event is admitted and disclosed by the petitioner in her supplemented affidavit filed today. Full stop. Next para. Be that as it may, comma, we find that the alleged contemner is paying alimony only to the tune of rupees 60,000 per month, which was directed in connection with a proceeding under the Protection of Women from Domestic Violence Act 2005, whereas the amount directed by this court was rupees 3,60,000 per month. Full stop. Next para. Thus, comma, there is a prima facie violation of not only the order of this court but also the direction granted in connection with the SLP filed by the alleged contemner against the order under contempt. Full stop. Accordingly, we'll issue a rule against you because you're in contempt.
My lord, I was needed some time. My lord,
Learned
here
counsel
no
for
file
the
issue.
alleged contemner seeks further time to clear off the alimonies. Full stop. However, comma, in view of the observations made above, comma, we are not confident that the
That was very
timelines
clear, my lord.
granted will be complied with by the alleged contemner, comma, particularly in the teeth of the gross violation of the direction even passed by the Honorable Supreme Court on May 13, 2025 to clear off all anomalies within 4 weeks from that date. Full stop. Thus, comma, let a rule do issue calling upon the alleged contemner to show cause as to why the alleged contemner should not be penalized in terms of the prayers made in the contempt application. Full stop. Such rule shall be made returnable on August 11, 2025 at 10:30 a.m.
My lord, grateful, my lord.
We file a show cause to that. A show cause will go. In that you disclose whatever.
My lord, my lord.
Thank
So
you.
grateful, my lord.
Grateful to your lordship.
বললাম না কারণ আর দিয়ে কি হবে এটা একেবারে রুলের দিয়ে দিই এটাই গ্রসলি ইনকন্টেন্ট সুপ্রিম কোর্ট বলেছিল যে 4 সপ্তাহের মধ্যে দিতে সেটা দেয়নি কল করুন
My lord, I went through the memo of appeal, my lord.
Pardon?
I went through the memo of appeal.
Oh yeah, you are requested. We'll move the matter. We'll just come back in 5 minutes and
Grateful.
very good, Mr. Mukherjee.
Grateful.
Yes, Mr. Mukherjee. What is the matter about? First, tell us what is the defect. There is a defect.
My lord, for that I need to have access to the file. I am
Then you
unaware
get
of the defect.
access to the file. Let us just check up first. Defect number 2 still persists. Appellant number 5 has not executed Wakalatnama.
My lord, this is a second appeal from 2003, my lord.
You have filed an appeal on behalf of 10 appellants, right? No, there is no signature of appellant number 5 in the Wakalatnama. That is the defect stated here. So how do you overcome that? Sukhoda Mohatni.
My lord, in that event, many of the petitioners are deceased, as appellants are of deceased at presently. So we can come up with a new Wakalatnama, my lord.
How soon can you do that? How soon can you do that? Have you got contact with your clients?
My lord, yes. 2 weeks time, my lord. In the meanwhile.
Why 2 weeks? Where do they stay?
My lord, Purulia.
Oh.
And my lord, another innocuous prayer, my lord, since my lord, the second appeal, as your lordship, my lord, will see of 2003. And my lord, it has not yet been admitted. We have received the brief this year. So, my lord, the difficulty is that I do not possess, my lord, the copy of the judgment of passed by the learned trial court and the first appellate court. So, my lord, may I have the liberty to obtain a certified copy of these two judgments, my lord? Because even my clients do not have them.
Certified copy is very difficult.
Otherwise, my lord, I am not being able to, my lord, read the judgments, my lord, from where I can get a insight of the learned trial.
Learned counsel for the appellant submits that the appellants will require he will require a fortnight's time to obtain proper Wakalatnama from the appellant number 5 to rectify the second defect as pointed out by the stamp reporter. First up, next para. It is further submitted that the appeal is quite old and the present advocates have been currently briefed, comma. The latter do not have copies of the judgment and degree of the trial court, and certified copies thereof may be handed over to them. First up, next para. Accordingly, let the appeal be sent down to the department for the time being. First up, the department shall, comma, upon appropriate costs being put in by the appellants, comma, furnish duly certified copies of the memorandum of appeal along with the judgments and decrees of both the courts below, annexed thereto, to the learned advocate for the appellants. First up, next para. As a duly certified photocopies, duly certified photocopy. And next para, the appeal shall next be listed under the same heading in the monthly list of August 2025. You please file your Wakalatnama also in the meantime for 5.
In the meantime, my lord, we'll file the Wakalatnama, my lord. De reach. Grateful.
Item number 25, my lord, I am for the appellant petitioner.
What is the defect?
My lord, there are so many defects, my lord. I have cured some defects on my part, my lord. First, my lord, the name of the learned trial judge.
The defects are more than the grounds of appeal.
Yes, my lord.
Name of trial judge, preamble that you have corrected.
Yes. Just, my lord, title, Odhikari Basu
Odhikari was missing, right?
Yes.
Name of
My lord,
deceased
the name
appellant
of the deceased appellant number 7 in the cost title of the instant memo appeal may be deleted. I have deleted, though, my lord, very old appeal, my lord, I have filed the Wakalatnama in the department. After that, I have...
With the name of the deceased person?
No, my lord. No.
Next, second defect is cured. Third is,
my lord, the
date
date
of judgment
furnished in the respective decrees of both the courts below are
that
wrong.
has to go down to the court below. You cannot do anything.
Yes, my lord. Moreover, the decree of the lower appellate court does not bear the full cause title. Instead, a short...
Very well. Nothing about, nothing to do by...
Yes, my lord. On my part, my lord.
Names of parties will be verified afresh, right? Wakalatnama, acha. Appellant number 8 has not executed Wakalatnama.
No, my lord. LTA appellant number 21, she died, my lord.
21 has died.
Died.
Have you filed any substitution application?
No, my lord.
Then how can you take up the appeal? If somebody
Did not-
dies,
did-
you have to
did
take
not
up the...
inform my client, my lord, about the death of the.
And what about cost title 7 Ko to Gho? They are minors.
They are now majors, my lord.
File an appropriate application. The learned advocate for the appellant is granted leave to file an additional fresh wakalatnama incorporating the signatures of appellant number 8 and an appropriately identified left thumb impression. শুধু ওই appellant number 8 টাই থাক, and থেকে বাদ দিয়ে দাও। So next para, insofar as appellant number 21 is concerned, comma, it is submitted by learned counsel for the appellants that the said appellant has died in the meantime. Full stop. The appellant shall take out appropriate application for substitution, comma, upon condonation of delay and setting aside abatement, comma, if required, comma, at the earliest. Full stop. Next para, insofar as the cause title of the memorandum of appeal being bereft of the representation of minor appellant numbers 7 Ko to 7 Gho is concerned, comma, leave is granted to the learned advocate for the appellants to file a short application seeking leave with a prayers by the said appellants seeking leave to prosecute the appeal in their own name upon attaining majority. Two applications. Yes. One is this application. No, Vakalatnam will have to file with appellant number 8. An application, these two people will file that we want to proceed in our own name, and substitution application for number 21.
21.
Do this. We will take it up in the monthly list of August. Can you file these applications in the meantime?
Yes, my lord. Other defects?
Other defects, it has to be sent down to the trial court. We'll do that after hearing the
application.
As to the other defects are concerned, comma, since those can be rectified only by sending the file down to the trial court, comma, we shall pass such directions after hearing the appeal under Order 41 Rule 11 of the Code of Civil Procedure. Full stop. Learned counsel for the appellants is requested to take steps immediately for curing the above curable defects as indicated earlier. In the meantime, full stop, the appeal shall be listed under the same heading in the monthly list of August 2025.
My lord.
One Vakalatnama by appellant number 8, one substitution application for 21, and these 7A Ko to Gho. Minor. They want to prosecute the appeal in their own name upon attaining majority. Give the dates of attaining majority.
My lord, grateful.
My lord, the advocate on record, Mr. Abhijit Chakraborty's father is very ill. He is not coming.
Father is ill?
Yes, my lord.
That's very well, but in the meantime, you have to correct the defects. Let us see. Trial court judgment and degree certified copies you have to file.
My lord.
What about name of respondent number 5? We should at least be prepared with these defects.
My lord, I will tell him.
An adjournment is sought on behalf of the appellant.
Adjourn for a week, my lord.
Full stop. Let the matter stand adjourned till July 14, 2025. Full stop. In the meantime, comma, the defects pointed out by the additional stamp reporter. Defects pointed out by the stamp reporter shall be rectified by the learned advocate for the appeal. Please check up the defects and remove those.
Item number 27, I am appearing for the appellants, my lord, along with my learned junior friend. But on the last occasion, my lord was pleased to inquire from my learned junior friend as to whether the delay was condoned.
Yes.
My lord, the delay was condoned, my lord. If your lordship, my lord, will kindly goes through order dated 3rd of January 2019. Passed by their lordships, Honorable Justice I.P. Mukherjee and Justice Amrita Sinha, my lord, as the lordships then was. Well, as the delay was condoned.
Yes.
And the appeal was admitted.
No formal order of admission.
My lord, LCR was called for.
LCR called for, but this is misappeal. Will deem it to have been admitted then.
My lord, the informal paper books are prepared. My lord, that is with me. But
What
my
about
lord,
service of notice on the respondents?
my lord, I'll cause a fresh service, my lord, because there is a previous service, my lord. The affidavit of service, my lord, will find in the record.
No, not that. We have to put in the requisites for service on the.
My lord, the LCR for the LCR.
Oh, that direction was never given.
No, my lord, that direction was also given, my lord.
Yes, service of notice of appeal.
23rd of the March
31st,
2022, my lord.
As the respondent is not appearing, service of the notice of appeal upon her by January 31st, 2019.
My lord.
What about that? You put in fresh requisites.
My lord, I'll put in fresh requisites both for the service upon the respondent as also the LCR, my lord. Because I presume the LCR, my lord, has.
Special messenger have not deposited.
No, my lord. Not deposited.
We find from the order dated January 3, 2019 that the delay in preferring the same was condoned and the coordinate bench had directed that the appeal should be expedited and pass necessary directions for bringing the trial court records and service of notice of the appeal. Hence, we deem the said order to be an order of admission of the appeal as well. Next para, on the prayer of learned counsel for the appellant, we extend the time for depositing special messenger costs for bringing the trial court records for a week from date. The appellant shall also put in fresh requisites for service of notice of the appeal on the respondents within a week. Liberty to the parties to mention the appeal for inclusion as and when the same is otherwise ready for hearing.
I'm grateful to your lordship.
My lord, in item number 20, Mr. Ujjwal Rai is appearing on behalf of the appellant, my lord. He's on court number.
Tell us what is the defect.
My lord, the defect is, my lord, it says that the appellate court's order, my lord, the names that has been there for the respondent is not appearing in the memo, my lord. One of them has passed away, my lord. That is why it is not there, my lord.
So then you have to file applications for substitution.
My lord.
Why haven't you filed?
Seeking 1 day's accommodation in this regard.
1 day you can file application.
My lord, I cannot, my lord.
Who has died?
My lord, before filing of the second appeal, my lord, the appellant, my lord, it is Osima Guin, my lord, has passed away, my lord.
Before filing of the appeal?
My lord.
Then you have to file an appropriate application not for substitution but seeking leave.
No.
Which appellant has passed away?
Lord, it is Telology.
Who has passed away? The respondent number 1.
Lord, respondent number 1, my lord.
Then you have to just file an application to that effect.
My lord.
Topon Kumar Sadhu Kumar, what about the heirs of that respondent number 1?
Possession of any instructions, my lord.
Someone was mentioned as respondent number 1, defendant stroke respondent number 1 in the trial in the courts below.
My lord, it is Osima Guin.
What was the name?
Lord, it is Osima Guin, my lord.
Osima Guin.
My lord.
So what about her heirs?
I have to take instructions, my lord. I'm not in possession of any instruction being led by Mr. Rai, my lord. So seeking only 1 day's accommodation, that is what.
On the prayer of the appellant, let the matter stand adjourned for the day.
Grateful, my lord.
Give your name only, not Mr. Rai.
My 29, my lord, I am for the appellant. My lord, the appellant came before your lordship. He is the plaintiff in the suit. My lord, he filed an application under Order 39, Rule 1 and 2. That was allowed.
Yes.
Subsequently, my lord.
Your application was allowed?
Yes.
Achha, then?
Then, my lord, what happened, my lord? I sought for police help.
You?
I sought for police help.
Achha.
That police help prayer was rejected by the trial court. Thereafter, I approached before the lower appellate court, and the lower appellate court turned down the prayer of police help at interim stage. Challenging that order, my lord, I have come. My lord, I know, my lord, what your lordship's mind going through.
You know what we think?
I can.
So we are thinking something else.
My
because the impugned order says that the prayer for passing an order of ad interim injunction is rejected.
Yes. Yes.
You say police help was rejected.
Initially, police help was rejected by the trial court.
What is the impugned order? Order number 2.
Order number 2.
Oh, in the misappeal itself, this was.
Yes, yes.
No, you have challenged the refusal of ad interim injunction is miscellaneous appeal.
Yes, miscellaneous appeal. That I am telling.
What are you saying? Police help and all this?
No, police help. Initially, my lord, this suit filed by me. I got order of injunction. Thereafter, I sought for police help. Police help was rejected by the suit court. Against that order, I preferred misappeal. Misappeal order number 2, order dated 23rd of March 2021. Last 3 paragraph from bottom. In the first page.
No, in the trial court, you got an order restraining the defendant from dispossessing you.
Yes.
Or disturbing your peaceful person or doing any illegal act or mischief in respect of the suit property or construction.
Yes.
You wanted further injunction.
I sought for police help. That was rejected.
That is not reflected anywhere.
But that is the page, first page, order number order dated.
In the present memorandum of appeal, you have challenged the order dated 23rd of March 2021.
Yes.
23rd of March order says.
From the record, from the bottom.
From the record, yes.
It appeared that on 17th March 2021, the record was put up and the police help to execute the order was sought. Learned trial court, by the impugned order, rejected the prayer of the appellant for police help and modified the above order. Then the order was quoted. Learned trial court also directed to as notice that is not important. In the next page, in the impugned order of the trial court has restrained the defendant in the suit. Got it, my lord?
Yes, that was in your favor.
From dispossessing the plaintiff and risk person. Such variation in the next paragraph.
What variation did you want?
Such
police help is a variation to the injunction order.
That is the observation of the court.
You got an injunction order that was modified to your benefit also. You sought police help.
Yes.
Police help was rejected. First of all, a miscellaneous appeal is not maintainable against that.
That's
was what was going on in my mind, which you apprehended.
Yes.
But it is further going on in your mind how the trial court could say, the appellate court could say that your police help application is a modification of the injunction order.
That is true.
Anyways, no appeal is maintainable. So we dismiss your appeal. And you have filed a second appeal against that.
No, FMA.
FMA against an order passed in misappeal.
That's I know, my lord.
You know, then why did you file?
I have not
returned
filed.
The money of your client.
It is change brief, my lord. It is change brief. I have not filed, my lord. It is long back in 2021.
To return the fees which you have taken and the fees taken by your.
My lord, I am requesting before your lordship
to dismiss.
Grant leave of section 14 so that I can challenge in revisional jurisdiction. That is my only prayer before your lordship.
The present appeal poses certain peculiar circumstances. Full stop. When counsel for the appellant submits that the plaintiff appellant obtained an order of injunction, ad interim injunction in the trial court. Full stop. Subsequently, the said order was modified. Full stop. However, comma, even after the modification, comma, the same inured to the benefit of the plaintiff stroke appellant. Full stop. To implement the ad interim order of injunction, comma, the appellant filed an application for police help in the trial court. Full stop. Such police help application being rejected, comma, a miscellaneous appeal was preferred. Full stop. In connection with the said miscellaneous appeal, comma, by the present impugned order, comma, an ad interim injunction, a prayer for ad interim injunction was purportedly rejected. Full stop. Learned counsel for the appellant, comma, however, comma, insists that the only prayer sought was for police help, which the appellate court below treated to be one for modification of the injunction order. Full stop. Next para. The peculiarity of the matter is that first, comma, no appeal is maintainable against an order rejecting police help. And secondly, comma, there was no occasion for the appellate court to treat the to entertain the appeal at all, and stroke or even if entertained, comma, to deem the rejection of a police help application to be a modification of the injunction order of which implementation was sought. So next para, be that as it may, comma, in any event, comma, no further appeal lies against an order passed in a miscellaneous appeal. Full stop. Accordingly, FMAT 351 of 2021 is dismissed as not maintainable, with liberty to the appellant to challenge the order of the trial court refusing police help by way of a properly constituted challenge before the appropriate court. Full stop. Can 1 of 2021 is accordingly dismissed as well. No arrest to cost.
Kindly allow me to take back the
certificate. What will you do with the certificate copy? This is the certificate copy of the appellate court's order. We are saying that the appeal, misappeal is also not maintainable. You withdraw the misappeal and go and file a revision application against the original police help rejection by the trial court.
Grateful, as you lord.
Grateful. Thank you. What will you do, Mr. Chatterjee? Repeat what you said.
Return the fees.
No, not that. What is your course of action legally? I mean, what will you do now?
I filed the 227.
First of all, you go and withdraw your miscellaneous appeal, which you have filed wrongly because no miscellaneous appeal lies against police help rejection. Go and withdraw, say it is not maintainable, give me liberty to file a proper revisional application. Do that, take that leave, and then from that court, you take back your certified copy of the police help, which is lying there. And move out to 27 application. Next. Yes.
In this matter, I am appearing on behalf of the appellate.
Yes, Mr. Rai.
The
Heirs of the deceased.
My client is not turned out. Kindly,
Dismiss for default.
Keeping this submission on behalf of me, kindly record it.
Learned counsel for the appellant submits that despite repeated efforts, comma, the learned advocate for the appellant was not instructed by the appellant to move the appeal, full stop. We also find from the order dated June 9, 2025, that no steps, that all those steps were directed to be taken by the appellant for bringing the heirs of the deceased respondent number 1 on record, comma, nothing in that regard has been done as yet. Full stop. Next para. But respondent number 1, what is the what was the suit for? You are the plaintiff. Suit for?
Suit for partition and injunction.
Accordingly, comma, FMA 115 of 2023 is dismissed as regards dismissed for non-prosecution as regard the appellant number 1 is concerned, full stop. In any event, comma, the appeal has abated insofar as the respondent number 1, Amiyo Kumar Mitra, is concerned. Full stop. Next para. Interim order, if any, stands vacated. There will be no arrest to cost.
I'm the plaintiff appellant.
You're appearing for fruit, potato, or the others?
No, I'm
We
for
are
the
for-
plaintiff appellant. He is
They are
It's
fruit, potato,
Greater
lemon.
Calcutta fruit, comma, potato, and others. So you're appearing for
No, lemon
you're
is
for the others.
Yes.
lemon is also there. Lemon is also there.
Lemon is also there. Who is appearing? You're for the lemon.
There is an application for condonation of delay. There is a delay of 40 days.
40 days. Yes. Seriously opposed.
My lord, the liberty be given to file the opposition.
But
My
what
lord, only
opposition?
difficult-
40 days delay. Lord.
My lord, but the explanation has not been made properly.
My lord, only
That is the
difficult.
Let's see the explanation.
Only
40
difficult.
days delay.
Only difficulty, my lord. We have been served with an incomplete copy, my lord. From
What
the
copy?
incomplete copy of the
Incomplete
petition.
copy.
My lord,
There
why?
was
My-
no caveat. My learned friend Miller Junior Miller wrongly had supplied. There was no requirement to serve Miller. This is before admission.
So, my
serve
lord,
and come
it has
back.
been served. My lord,
Now served.
it has been served, my lord. My lord,
Incomplete means what was not there.
my lord, the page where the stamp, the date for application of taking out the certified copy and all that, that page is missing, my lord. My lord, we cannot ascertain, my lord,
and
at
before your
what
lordship
time,
and the-
my lord, they have taken.
Stamp reporter has given that
My
report.
lord, that is the reason, my lord. That
Stamp
will not be
reporter has
explained,
given
my
the
lord.
report.
What?
When the certified
Delay
copy
has
is
not been explained properly, my lord.
No, in the, application for certified copy of the impugned order.
My lord, my lord.
Yes, Mr. Bhattacharya, have you checked up?
I tell you, Lordship, Millard, what happened, Millard? It's all, Millard, the application, Millard, delay was due to Millard misconception. Millard, the advocate, Millard, we were Millard informed that the limitation from City Civil Court is Millard 90 days. We were proceeding on that basis.
This is against order.
Millard, two things. Millard, they have captioned the application under order section 16 of the Civil Procedure Code, but their
Order 7
main substance is Order 7, Rule 10. City Civil Court has no jurisdiction.
10 or 11?
10. 10. Well, order under challenge, Millard, is order number 10. The first order. 10th August 2023.
Yes.
Well, ultimately, Millard, what has been allowed, Millard,
yes,
is Millard an application under Order 7, Rule 10. But the Millard defendants have classified the said application as Millard Section 16 of the Code of Civil Procedure.
My lord, nomenclature.
That doesn't matter. Millard, perhaps
You sought for a rejection of the plaint or return of the
My
plaint?
lord, return.
What was the
My
prayer?
lord, there are several defendant, my lord. Each of them took out several applications, my lord. One of them was 710, my lord, under Order 7 Rules 10. One was under Order 7 Rule 11, my lord. My lord, the primary round taken by each of the defendant was that, my lord, that the entire asset
So we'll
for
come
the
to that
subject
first.
matter.
First, the appeal, the
Application, my lord, for condonation, my lord.
application has to be allowed. Yes, what is your explanation?
Millard, explanation, Millard, kindly comes to Millard from paragraph 3 onwards, Millard. Your petitioner states that thereafter on 18th of May 2023, the matter was taken up for hearing of the application under Order 39, Rule 1 and 2 of the Code of Civil Procedure. And after hearing the learned advocates of the plaintiffs, the learned court below was pleased to grant an ad interim order of injunction, thereby restraining the defendants, men and agents from alienating, creating any third-party interest over the suit property, and restraining from construction over the suit property. Further, the defendant number 1 is restraining from giving any effect to the decision by which allotment of land was settled in favor of 107 members. Your petitioner states that the defendants entered appearance by filing written statement. Written objection, Miller, that is not very much. It kindly comes to paragraph 5. Your petitioner states that thereafter on 10th August 2023, the application under Order 7, Rule 11 of the Code of Civil Procedure and an application under Order Section 16, Millard, this is what, Millard, I was saying, we read with Order 7, Rule 11 of the Code of Civil Procedure filed by the defendant number 4, and the application under 151 of the Code of Civil Procedure filed by the defendant number 5 was taken up for
These are not the explanations. The explanation starts from page para 7.
Para 7.
Read it.
Your petitioner states the order was passed on 10th August 2023 before the learned court below. Thereafter, on 16/8/2023, your petitioners came to the chamber of the learned advocate appearing in the court below, and after consulting the learned advocate appearing, your petitioner decided to challenge the order passed by the learned court below before the High Court. Millard, this is what, Millard. Then, Millard, paragraph 8, consultations were held. Then, Millard, this paragraph.
30 days is the limitation is 30 days.
30 days, my lord, we were, my lord.
What is the explanation?
My lord, no
You
explanation
say
given.
your petitioners on 15/9/2023, your petitioners had handed over documents.
My lord, when the certificate
Yes, my lord, that is
was
there.
obtained,
That is immaterial. They even handed over the copies
My
after
lord,
the limitation.
in fact, this 40 days, my lord.
Kindly allow me to file a supplementary affidavit.
Do that.
And my lord, kindly direct them to supply us a copy wherein we can
Very
find that particular page of certified copy from where we can find when the
Which certified copy of
my
the
lord,
trial
the
court
imputed
order?
order, my lord. They have taken
No, no,
up-
they are not duty bound to do that.
my lord, these 40 days, my lord. Yeah,
They are
subject to
not
correction.
duty bound to do that.
My lord,
You can
it has-
check the records,
my
but they are
my
not duty.
my lord.
Learned counts on the prayer of the appellants, comma, leave is granted to the appellants to file a supplementary affidavit to the condonation application within a week.
Within a week? Within a week.
Within a week from date. Full stop. Copies thereof shall be served on the learned advocates appearing for the respondents. And a receipt in that regard shall be filed on the returnable date. Full stop. The matter shall next be listed for hearing on July 16, 2025. Would you like to use opposition?
My lord.
আচ্ছা তা ঠিক আছে তাহলে জুলাই 16টা করো না ওটা কেটে দাও লাস্ট সেন্টেন্সটা
opposition, my lord, they are
affidavit in opposition if any shall be filed by July 21 2025 full stop reply thereto if any shall be filed by July 28 2025 the application shall be listed for hearing on August 5 2025.
my lord, a formal order for admission, my lord. FMAT.
Admission?
Oh, section 5 is
Section
pending.
5 is we are taking out the objection, my lord.
Under the heading application. No, under the same heading.
My lord,
We'll take up the section 5. If you dismiss, gone. If you don't dismiss, allow, then we'll take up the matter for order for you.
Only one thing, my lord.
And you come prepared on the appeal also. If you
I'll
allow the section 5, generally the
yes,
tendency
yes.
of court is to allow
Yes,
section
yes.
5.
Yes,
All
I
courts.
will be.
If you allow, we may take up the appeal itself
Yes,
for here.
yes, yes.
You come prepared with the documents. Very short matter.
My lord, one thing, my lord, we have annexed all documents, my lord, whether my lord opposition to my lord section to the stay application is required, I do not know. We have also filed
We cannot direct that at
written,
this stage.
written objection in the trial court, my lord, also
If they have
there.
missed out any document in the stay application, you can come prepared with those documents. Give copies to them. We'll take up the.
My lord, in the meantime, my lord, there was an ad interim order of status quo, my lord. My lord, there.
Section 5 has to be allowed first. No.
My lord, that my lord, if allotment is done, my lord, nothing, my lord.
Allotment, this is against what?
What happened, my lord? Our grievance was the society has to, my lord, allot the lands, my lord, after doing lottery. That has not been done.
Try not to allot in the meantime. If you allot in the meantime, we'll set that aside. If you allow his appeal, we'll set that aside.
My lord, that is the whole difficulty, my lord. And in the meantime, my lord,
Section 5 stage, we can't do anything.
we were enjoying, my lord, the order of, my lord, injunction in the trial court, my lord, that is there. And section,
Enjoyment over now.
Section 5, my lord, Justice
Now sufferance.
Justice Ashamukul's pulse judgment is there, my lord, 81 Calcutta, my lord.
No, not at this stage.
And that is, my lord.
No, Mr. Bhattacharya. No stress. First, the section 5 has to be.
Lordship, I am for the petitioner.
What is the matter?
Lordship, there is a caveat and the notice has not served yet. So
Why not serve?
Lordship,
Caveat is before you. Serve it right now.
Lordship, kindly give 1 week time.
Where is your copy? Where is your brief?
Lordship, my senior actually has not come to court today.
So what can we do? You are the junior. It has come upon your mentioning. Why shouldn't you dismiss for default?
Lordship, kindly 1 week time.
You are mentioning it has come. You have to come prepared, sir, with a brief at least. This is not done. Who is your senior?
Lordship, SK Abu Azuddin. Lordship, I am newly joined. I have no knowledge about this matter.
How new?
Only few months.
How many months?
1 month.
Full grant time. The appellant shall serve a copy of the application, corrected application on the learned advocate for the caveator by tomorrow. Full stop, the matter will be taken up under the same heading on July 14, 2021, next Monday. Give a copy by tomorrow. Yes. Give your names. No, his name also. এটা দিয়ে পুরো স্যালাড হয়ে যেত, fruit, potato. লেমন হ্যাঁ মামলাটা নিয়ে স্যালারি করবো যদি না time
Lordship, I just received instructions from the seniors clerk that he's on his way.
that's your problem sir what is the matter about
Lordship, I just
we'll dismiss for
received
default
mere instructions for the same. I'm looking for a short passover, Lordship.
passover
Yes, Lordship. He's on his way.
Mr. Karim
Yes, Lordship.
where will passover he is more or less regular
But for both the matters 33 and 34.
Pardon?
Item number 33 and 34.
No, 1 minute. The section 5 has not yet been allowed.
Lordship, I'm not in this matter. I just received
Wait,
my
wait, wait a minute. অ্যাপিল ডিসমিস ফর নন প্রসিকিউশন হয়েছে নন প্রসিকিউশনের জন্য ডিসমিস হয়েছে তাহলে কিভাবে হবে মেইনটেইন হবে all right let him come we are passing it over 33 and 34 pass over রইলো মাসু দিলে
But 33 would the lordship place at 33 and 34 both the two matters for I am appearing would the lordship place that to my lord just take up 2 p.m. so that I can join with the lordship my lord.
we have passed it over Mr. We have passed it over just now.
Yes, Lord, 33 and 34, both the two matters, Lordship.
Next matter, please.
My lord, I beg to appear for the appellant. My lord, there has been a delay of 4 days in filing this appeal. My lord,
Sir,
we have, only one thing. My lord, on Friday, my lord, it has been affirmed. My lord, the CAN application, we are yet to receive the number. My lord, it will be filed within 2 hours. My lord, we'll get the number. My lord, I have the affirmed copy of
We'll postpone it for a week.
Lord, I can serve, my lord, if my lord.
No, if it's not in the list, we cannot do it. We'll postpone for a week. In the meantime, you have that application mentioned when you file. Tomorrow, mention it so that we can tag it along with this. On the prayer of the appellant, in order to enable the appellant to file a condonation application, let the matter stand adjourned till July 14, 2025. You please mention the condonation application tomorrow so that we can tag it along with this.
Mr. Kushal Chatterjee is appearing for the
For the respondent, my lord.
Yes, Mr.
Passover, Mr. Kushal Chatterjee is appearing for the.
You are also there. You are sufficiently senior. Yes. Come to the microphone. Move the matter.
Lord, I am not briefed in this matter, my lord.
Take your file. Move the matter. Enough these adjournments. What is the matter about? You have to apprise us at least.
Be kind enough to give me 10 minutes to go through the brief.
Use the microphone. Can't hear you.
Be kind enough to give me 10 minutes to go through.
No, we are unkind. Move the matter. Affirmance or reversal, at least apprise us what the matter is about. You are a chamber junior of Mr. Chatterjee. So, should be prepared with the matter. What do you do in the chamber? You don't prepare for the next day's matters. You go to the chamber regularly. So you must know what the matter is about. What is it?
My lord, suit for eviction, my lord.
No, you are not his chamber junior. Yes, what is your name?
Oishik Chatterjee, my lord. Oishik Chatterjee, my lord.
Yes, Mr. Chatterjee.
My lord, this is a decree of affirmation, my lord.
You are the defendant.
I am the defendant in this.
A decree for?
My lord, eviction decree. I perhaps a licensee holder, my lord.
Licensee. Your case was that you were a tenant.
No, my lord. Perhaps it's my case that I am a permissive occupier.
Your case was that you were a licensee.
Yes, my lord. That is what.
Where will pass over? He's coming.
Yes, he is coming, my lord.
Pass over, thak. We are passing it over. Licensee. He sought for declaration that he is a licensee. He sought for declaration that you were a licensee.
I have to go through.
What is the matter about
eviction of licensee, my lord, decree?
What was his defense? That he's a tenant?
No, my lord, neither a tenant nor a licensee. Now, my lord, that is what confirmed that.
No, what was his defense? In the written statement, he did not say that he is a tenant.
My lord, in the written statement, my lord, yes, my lord. My lord, they have now come with a, my lord, the new story. My lord, different story. That, my lord, amendment application was filed, that was rejected. Even, my lord, 47 application rejected, my lord, on 30th June.
No, that is a different chapter. What was the defense in the suit? We are asking only that. He did not take a defense that he's a tenant. This is the first time in a license eviction suit we are hearing that.
My lord, he's.
We are not trying to convince you that if he did not take, he did not take. What was his defense? You are so sure that he will dismiss it.
Yes, there are two courts, my lord.
Anyway, pass over. Let us call on.
Much obliged, my lord.
You prepare yourself in the meantime, Mr. Chatterjee. We will take it up after 10 minutes. If the other Mr. Chatterjee does not come, we hear you. Yes. Yes, you are appearing, Mr. Medora? Yes. What is the defect first? Let us check out.
Yes, I'm not aware, my lord. I saw it in the list.
Should be. Your junior should be, not you. Whoever is there on record. Husband's name of the sole appellant does not tally with the trial court's decree. Forgotten in the heat of litigation.
No, it's a changed brief, my lord. It was filed by somebody else, then it came to the legal aid. So,
So you correct the name of your husband at least.
Yes.
That much you can do.
yes.
Unless this is the matrimonial suit.
No, there's no matrimonial issue out here.
An appeal value furnished in the instant memo does not tally with the certified copy of the decree. So valuation 65 you have shown. Let us see the decree once. Value shown in the trial court was 100 probably, 100. Here you have shown 61.
Here,
You have to correct the valuation and the name of the husband of the appellant.
yes, we'll correct that.
Are you ready with the matter
I'm ready.
otherwise?
I'm
So
ready.
then we'll give you that liberty. You do that in the course of the day and we'll hear you.
Great.
Yes. No, you don't have a right of hearing, ma'am.
At this
Yes.
point, no, but I have an injunction application also.
Injunction you have.
Yes. But kindly take
No,
up
you
the
are asking for a passover. Use the microphone.
1 day accommodation, my lord.
You are on caveat.
Yes, ma'am.
You lodged a caveat.
Yeah.
Was there a caveat?
I'm not aware, my lord. It's a changed
There
brief,
was
so
a
I'm not aware.
caveat.
There was no.
There was a
There
caveat.
was.
Yes.
We had we lodged a caveat.
Then we must have a copy of the application. Where is the copy?
Sir, Lordship, it's with my senior. He is not.
Very well. Leave is granted to the learned advocate in record for the appellant to carry out the necessary rectifications to remove the defects in the memorandum of appeal during the course of the day. Full stop on the prayer of the caveator. Let the matter stand adjourned till tomorrow.
The admission your lordship will consider today?
No. Carry out the corrections.
Right.
If we consider the admission, we have to relegate the application to the other bench unless you immediately
No.
take it up.
Great. husband and namta ठीक करे और evaluation.
Please check up the back, the reverse of the memo, the first page, reverse of the first page, name of husband and valuation.
My lord.
Well, 38, I am paying only one week adjournment. Mr.
What do you mean by only?
Soil Gandhi Bhattacharya is appearing.
Who is appearing?
Soil Gandhi Bhattacharya.
You are also there.
His high fever, he has not come. On his instruction, I am praying.
On the prayer of the appellant, let the matter stand adjourned for a week and be listed next on July 14, 2020. কেউ ম্যাটারে রেডি হয়ে আসবে না সব মেনশন করার সময় সবাই আসবে
I apply for the appellant.
Yes, yes, Mr. Theory.
Blood defendant's appellants suit for eviction of a licensee. There is a defect.
What is the defect?
I have not seen.
Why are you crying?
No, I have not seen.
You have not seen that, so you should cry then. Respondent number 225 in certified copy of decree. Respondent numbers 225 in the appellate court decree have not been implemented in the appeal, Mr. Theory. Why? Who are they? Pro forma respondents. Let us see.
Yes.
Yes, 2 to 5 are there. And let us see the second defect. 2 to 5%. In the preamble of the appeal, Mr. Theory, you have given the dates of signing of the decree also. You know, date of decree is the date of the judgment. So that we are giving you liberty to carry out both the corrections.
Yes.
But please carry out the corrections even if you dismiss your appeal.
Yes, yes.
You ensure that.
Yes,
Leave is granted to the learned advocate for the appellants to carry out the necessary rectifications in the memorandum of appeal by introducing the names of the respondent numbers 2 to 5 of the first appellate court, and to delete the surplus mentions of the decree signing dates from the preamble of the memorandum during the course of the day. Full stop. The appeal is taken up for hearing under order 41 rule 11 of the court. There is no caveat.
No.
So eviction suit, you are the defendant.
I'm the
Licensee eviction,
Licensee
lost in
eviction.
both courts.
Lost in both the courts.
What is the defense?
Well, only one defense. But a suit has been filed claiming relief against the all the defendants. Suit filed claiming relief against all the defendants. Subsequently, one of the defendants died. Well, no substitution was effected. Well, a decree was passed against the dead man, and against that appeal was filed. And well, in appeal court, it was pointed out that the decree was passed against the dead person. The appeal court proceeded on the basis there is absolutely neither a proper party or necessary party, so it can be proceeded. This is my with the deepest of respect, best point.
Why not necessary party?
Well, I don't know. Well, can you see? Well, first of all, well, can you see the appeal court's judgment? Well, my learned junior was persuaded by the first paragraph of the appeal court judgment. That's why he has mentioned the date of the decree and the judgment is different. First, appeal court judgment will first paragraph. This appeal is directed against the judgment dated such and such, decree dated.
No, that is a wrong mention.
Now, Millard, kindly turn, Millard, the appeal court's finding.
Your initial suit was dismissed, challenging the Hebanama by which plaintiff claims title. So that was dismissed, that chapter is over. So he has title. Therefore, you are
Kindly turn, Millard, inner page 5 of the appeal court judgments. Rather, it starts from inner page 4. Point for consideration. Points for consideration. First of all,
why should the entire suit have it? This is eviction of license, Mr. Theory. Not tenants in common or.
But Millard,
individual, each of the defendants have their own. The cause of action is against each of the defendants.
He has claimed relief against each of them.
Yes, but the reliefs are individual in nature. It would definitely abate in respect of the deceased defendant. But regarding the alive, you are the respondent, defendant was alive.
Defendant number 1.
Defendant 1. Against you, it did not have it.
A judgment against a dead man, Millard, dead person is nullity. Millard, your lordship knows, Millard, there is no doubt about that. Millard, the Supreme Court and so far as, Millard, the reasoning given by the London Appeal Court, Millard, kindly have a look, Millard. Page 5.
No, did you point out that?
Yes, it was pointed out.
Why didn't they carry out any substitution?
Millard,
but licensee, heirs don't come in.
Well, licensee, Millard, there is another twist in the matter, Millard. Initially, Millard, the oral Hivanama was executed by my father in my name.
Challenge failed.
Challenge failed. Now, Millard, subsequently, Millard, he has filed a suit, Millard, eviction of a licensee, but he has stated that these persons are having their interest in the property in question. That's why he also sought for Millard declaration to the effect the defendants have no right title interest in respect of the property in question. So, Millard, so far as this point is concerned, Millard, kindly see, Millard, whether how Millard appeal court had proceeded. Appeal court had proceeded.
Let's see that.
Kindly take, Millard, page 5. Inner page 5 of the appeal court judgment.
Yes.
During argument, appellant defendants categorically pointed out that before passing of the impugned judgment and decree, the defendant number 3 is such and such. That means that during the pendency of the title suit number 384 of 2018, one of the defendants, namely Oxkara Khatun, died, and the judgment was against the dead person. So the judgment is void on this count. On this point, the London Advocate Appellant referred one citation, AIS such and such and submitted that the Honorable Apex Court observed the judgment against the dead person is void ab initio. Unfortunately, the citation does not match with the AR journals. Now, my lord, there is no doubt the judgment against the dead persons is void one. It is settled principles of law. But on perusal of the trial court record, I find the defendant number 3, Akshara Khatun, was implemented as pro forma defendant. There is no relief sought for against the Akshara Khatun. The relief has been sought against the original defendant number 1, appellant number 1. So in this suit, the defendant number 3 was subsequently died was nothing but a proper party, not a necessary party, and there is no relief sought against the proper party, failing for his or her substitution in the event of his or her death may not vitiate the trial or judgment. Now, my lord, appeal court, lower appellate court will rely upon two judgments. These two judgments are, my lord, in respect of passive performance of contract. My lord, the judgment will not rely upon.
Sounds very catchy that decree against a dead person is a nullity, but if she was a pro forma defendant, no relief was sought.
So far as pro forma defendant is concerned, my lord, Lawsuit knows, my lord, there is no concept of pro forma defendant. Everybody is pro defendant. Now,
If no relief was sought, she was a surplus.
Relief was sought. My lord, can you see, my lord?
Was that?
Plain says
relief was given in the suit.
No, relief was not given, but relief
Let us
asked
see
for.
the decree of the trial court.
Yes.
Defendant number 1 is directed to hand over vacant position. So she was 3. We are
Yes,
looking
she
at the
was a
trial
3.
court's decree. Yes. And that must have been the prayer also.
Yes,
You got
yes.
a copy of the plaint?
Yes, I have. Acha, copy.
Just give us a copy of the plaint.
Only a copy.
Yes, the relief is sought only against principal defendant.
No, my lord, page 4 of the plaint says, my lord, উক্ত হেবালামা দমিনের সম্পত্তিতে 1 থেকে 1 হইতে 4 নম্বর বিবাদীগণে কোন রকম সত্ত্ব দখল বা ইন্টারেস্ট নাই. Though it was
No,
not
because
reading there is
no, the plaint must have also you cannot cull out a portion. Must have stated about the previous decree also.
Yes.
Your suit was dismissed.
Yes. Then there is no doubt. Well, my suit was dismissed. My appeal I failed. I did not file a second appeal. Well, that chapter is over. But only this point is this, well, whether the decree can be sustained. And my lord, in page 4 of the plaint. Sorry, my lord.
Rather, it has been stated 2 নম্বর হইতে 4 নম্বর বিবাদী বাদীর সহিত একত্রে তাহারা না আসায় মোকাবিলা বিবাদী শ্রেণীভুক্ত করা হলো, because they are proper parties only.
Paragraph 4 says, my lord, paragraph 4 just starts from thereafter, my lord. উক্ত হেবানামা দলিলের লিখিত সম্পত্তিতে 1 হইতে 4 নম্বর বিবাদীগণের কোন রকম সত্ত্ব দখল বা ইন্টারেস্ট নাই. নেক্সট প্যারাগ্রাফ 4. উক্ত বাদী তাহার পিতা উপরোক্ত হেবানামা দলিল মূলে হস্তান্তরের পর 1 নম্বর মূল বিবাদী ইতিপূর্বে চক্রান্ত করিয়া অন্যায় লোভের আশা আসমৃত করিয়া 1 নম্বর মূল বিবাদী ও 2 নম্বর 2, 3, 4 নম্বর মোকাবিলা বিবাদীগণ অন্যায় ও বেআইনিভাবে সম্পত্তির লোভ দেখাইয়া ভুল বুঝাইয়া মিথ্যা স্বাক্ষর ভাষায় 1 নম্বর মূল বিবাদী ও 2, 3, 4 নম্বর মোকদ্দমা মাননীয় কান্দিস্থিত সিভিল জাজ previous suit was discussed. So regarding the filing of the previous suit, and appeal was filed.
Statement was filed by whom?
Reading all.
Have you got a copy of the?
Acha.
বলা আছে জাজমেন্টে বলা আছে ট্রায়াল করে দেখুন.
Well, kindly see, my lord, trial court judgment, page 3.
1 minute.
Page 3, my lord, last paragraph. After receiving the summons, defendants.
We want to see a copy of that. What was the stand? Let us see the plaint case first. It is the plaint case is that it was your prior suit was filed by all, that was dismissed, appeal was dismissed. After that, it was given to defendant number 1 only for running his husking machine and all, permissive occupier, and relief has been sought only against defendant number 1.
Yes, so far as
they are at best proper parties, so they died or not, there is no difficulty. Entire relief sought against. Let us see, as the trial court, it has narrated the defense case.
Yes.
Let's see.
Kindly text me note page 9 of the trial court's judgment. Per contra, the specific case of the defendant, have you also got it? Page
Yes.
9. Per contra, the specific case of the defendant is that 30 years ago, the former owner of the suit property, Abdullah Khan, in his lifetime, settled the suit plot number such and such and non-suit plot number 1205 in favor of the defendant number 1 by Hora Leva. Thereafter, the defendant number 1 has been constructed his building house and installed oil mill and husking machine thereon. And he has been running the mill and by taking electricity connection in his name. Since Abdullah Khan has already transferred the suit property by oral Hivanama in favor of the defendant number 1 long ago, there is no question of execution of any deed of Hivanama by Abdullah Khan in favor of the plaintiff in respect of the suit property. The defendant number 1 is the owner of the suit property having possession thereof. The plaintiff has no sort of title interest in possession of the suit property. But having gone through the Exhibit 3 and Exhibit 4, it appears to this court that by filing a title suit number 22 of 20212, the defendant had challenged the validity of the gift Hivanama 1736 of 2010 entirely on the ground the plaintiff by practicing misrepresentations took the photograph signature and finger impression of Abdullah Khan and by practicing fraud in collection of the deed writer and witnesses, the manufacturer the impugned deed. The Abdullah Khan was not aware of such and such and never intended to execute the same at any point of time. It was further case that the entitled suit number 22 of 2012 in the suit number such and such, defendant number 1 has got his husking mill which is being run by electricity and the defendant has got the electric connection over the side mill and after
Theory, even if all the defendants have filed written statement,
yes,
other defendants did not claim any right at all. Their case is also the defendant number 1 is the
fight between the plaintiff and the defendant number 1. There is no doubt. It is absolutely in between the plaintiff and the defendant number 1. My case is not on the basis of the oral Hivanama. I was in possession. I have constructed the husking mill. I was running all this show. I had the electric connection and all these things. But the basic drawback is against me is not initial suit was dismissed and subsequent appeal was also dismissed. But the question is not whether all these things. I am in possession for the last 30 years. And this is the father and my father executed oral Hiva. And oral gift is absolutely permissible so far as the Mohammed law is concerned.
Take advantage of the death of a proper party.
But so far as this party is concerned, your lordship knows, well, the judgment relied upon by the lower appellate court, absolutely in context of another. Kindly see the judgment which has been relied upon by the lower.
We are not relying on any judgment.
Lower appellate court had proceeded on the basis suit for specific purpose of contact. These parties are proper party, necessary party, and all these things are there. Kindly see one paragraph of the.
That is regarding who is a necessary
and proper party. Kindly text paragraph 41, page 413. This is regarding implement. Application was filed whether it should be allowed or not.
No, this was for the description of a necessary 41.2 and 41.3. This is not only restricted to specific performance suits. This is a general proposition.
This is the general proposition.
A necessary party is a person.
Necessary party and proper party. Here in this case, what happened? Somebody has applied claiming that I am the necessary party. The court come to a conclusion who is the necessary party and who would not be the necessary or proper party. On these findings, this judgment was rendered. Now the question is whether the court can just kindly consider another judgment regarding that
Entire relief sought against defendant number 1. Even joint written statement says that defendant number 1 also you have a conflicting case that he was owner by adverse person. We have seen that.
Yes.
So everything towards defendant number 1.
I just said
the others were surpluses.
Just said another judgment. Kindly consider this.
This the trial court, the courts below did not, you are relying on.
Yes.
What is the
point is, this Your lordship knows, my lord, the decree against the dead person. My lord, kindly consider, my lord, paragraph 18, 19, 20, 22, and 28. And the settled proposition, my lord, whether, my lord,
Yes.
decree can stands. Paragraph 18, my lord,
Yes.
the order 22 rule 3.2, which applies in the case that the death of appellant plaintiff, and order 22 rule 4.3, which applies in the case of the respondent defendant, provides the consequences for not filing the applications for substitution of legal representative by the parties concerned within the time prescribed. And these provisions read as under. My lord, or these provisions were quoted. Now, my lord, kindly takes, my lord,
Abet against the deceased defendant.
at least, my lord, abated. So far as, my lord, this,
Let it, we will say that it has abated against the deceased defendant. What is the effect? We'll say that it has abated against it. That was the principle on which we were proceeding, in fact. Even if it abated against the defendant number 2, 2 has died. Defendant
three has died. 3 has died.
Even if it abated against the defendant number 3, nothing hinges on that.
May I just come back with one written statement? Let us see.
No, don't come back. Come back for some other matter. Both of you come back, you are invited to the court, but for some other.
Paragraph 21, kindly have a look.
Yes.
Paragraph 21, it says, my lord, is the fundamental principle of law laid down in such and such case. The decree passed by the court, if it is nullity, its validity can be questioned by any in any proceedings, including the execution proceeding or even the court order proceedings. Whenever such decree is sought to be enforced by the decree holder, the reasons is that the defect of this nature affects the very authority of the court in passing the decree and goes to the root of the case. This principle is in our considered view squarely applies to this case, and because it is a settled principles of law, the decree passed by a court or against the dead person is a nullity.
The present second appeal has been preferred by the defendant in a suit for eviction of licensee against a judgment of affirmance, whereby eviction was granted only against the defendant number 1 stroke appellant. Push up next para. Learned counsel appearing for the appellant submits that the impugned judgment of the appellate court is vitiated inasmuch as, despite the factum of death of pro forma defendant number 3 having been pointed out during pendency of the suit to the trial court, a decree was passed in the name of the dead person. First up, the appeal court affirmed such judgment. First up, learned counsel submits that a decree passed against a dead person is a nullity and cites for such proposition Omuk versus Omuk, reported at 2017 13 SCC 414. First up, next para, learned counsel further submits that the appellate court relied inter alia on Vidur Impex Janamta Chidio, reported at 2012 8 SCC 384, which was passed in respect of a suit for specific performance and as such does not operate as a binding precedent insofar as the facts of the present case are concerned. First up, it is thus submitted that the impugned judgments and decrees of the courts below being nullities, the present second appeal should be admitted on such ground alone. First up, next para. Upon a careful perusal of the judgments of both the courts below and the facts of the case, we find that there is a distinction between a decree being rendered as a nullity as a whole and the abatement of a suit only in respect of some parties. First up, next para. In Gurnam Singh Supra, cited by the appellant, the Supreme Court was considering the provisions of Order 22 Rule 3 within bracket 2 and Order 22 Rule 4 within bracket 3, which pertain to the abatement of a suit as against the deceased defendant. First up, next para. In such context, it was held that in the said case, the appellant and 2 respondents had expired during pendency of the second appeal, but no application was filed to bring their legal representatives on record. First up, as such, according to the Supreme Court, the appeal could be revived for hearing only when the proposed legal representatives of the deceased persons had filed an application for substitution of their names, and secondly, they had applied for setting aside of the abatement under Order 22 Rule 9 of the Code and making out a sufficient cause for setting aside of abatement and condonation of delay. First up, in such perspective, the Supreme Court observed that it is a fundamental principle of law that a decree passed by the court, if it is a nullity, its validity can be questioned in any proceeding, including execution proceedings or even in collateral proceedings, whenever such decree is sought to be enforced by the decree holder. Full stop. Next para. However, in the context of the present case, the said proposition is not applicable. Full stop. A comprehensive perusal of the plaint, a copy of which is handed over by learned counsel for the appellant in court today, shows that the entire relief has been sought only against the defendant number 1 stroke present appellant. Full stop. The defendant numbers 2 to 4, who were styled as pro forma defendants, were impleaded merely as proper parties, as per the plaint, since they did not join with the plaintiff stroke respondent number 1 in the suit. Full stop. Next para. From the judgments of both the courts below, we find that the impugned decrees have been passed only against the defendant number 1 stroke appellant. Full stop. Thus, the pro forma defendant numbers 2 to 4 were at best proper parties and surplusages, inasmuch as not a single relief was sought against them. Full stop. Apparently, the stimulus behind adding those pro forma defendants was that a previous suit had been filed by the pro forma defendants along with the defendant number 1 for declaration that a hibanama within bracket deed of gift bracket closed executed in favor of the plaintiff stroke respondent number 1 was a nullity stroke not binding. Full stop. Such suit was dismissed and the decree of dismissal was affirmed in first appeal and has attained finality. Full stop. Next para. However, in the present subsequent suit from which the current second appeal arises, the relief sought was only that a license was given to the defendant number 1 stroke appellant which subsequently was terminated, but the defendant number 1 refused to budge BUDG from the suit premises. Full stop. Since no relief was sought at all against the pro forma defendants, even if the pro forma defendant number 3 met her demise during pendency of the suit, nothing hinges on the same, since the suit could at best have abated against the pro forma defendant number 3, which would not vitiate the entire decree, which revolves around the defendant number 1 stroke appellant, as a nullity. Full stop. Next para. The argument that there is no concept in law distinguishing a defendant and a pro forma defendant is accepted. Full stop. However, it has been the established practice in courts to arraign parties as defendants where reliefs are sought against them and they are deemed to be necessary parties, and as pro forma defendant where they are perceived to be proper parties but no relief is sought against them. Full stop. Hence, even without going into the basis of such distinction, we find that the demise of the deceased pro forma defendant number 3 did not vitiate the decree as a whole, since no relief was sought against her in the first place, and even if the suit abated as against her, the decree against the defendant number 1 solely could not have been tainted in any manner by such demise. Full stop. Next para. In such view of the matter, we do not find that any substantial or arguable question of law has been made out in the appeal. Full stop. Accordingly, SAT 83 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Can 1 of 2025 is disposed of accordingly, is dismissed accordingly as well. No order as to cost. Sorry. Yes, the corrections, please. Thank you.
My lord, I beg to appear in this matter for the petition.
Yes, Mr.
My lord, difficulty on my part, my lord, so for the section 5 application is concerned, my lord, not happily drafted. I have checked, my lord, being an officer of the court, my lord, I request certain clarification required, my lord. For that reason, a section supplementary affidavit is required. Only for 7 days time to.
Where will grant you that time?
Just.
Did you direct you to serve?
No, my lord, if your lordship in the meantime.
We'll direct you to affirm within a week, serve both, and come back. We'll give a date.
Lordship, so kind of lordship.
Learned counsel for the appellant submits that certain relevant facts are required to be incorporated, and as such seeks to use a supplementary affidavit to the condonation of delay application. Such leave is granted. The appellant shall prepare and affirm such affidavit, supplementary affidavit within a week from date. Copies of the application, copies of both the applications as well as the supplementary affidavit shall be served on the respondent, indicating that the matter shall be listed under the same heading in the monthly list of August 2025. The appellant shall file an affidavit of service to that effect on the returnable date.
So kind of lordship.
Thank you. Hey, sorry. Onno password again.
No, my lord, 34 is
33, 34 are same.
No, my lord, 34 is concerned, my lord, one, my lord, stay application.
33 আর 34 দুটোই পাস হয়েছে।
একসাথে না,
34, yes.
My lord, 34 stay application has been filed, but that has been on tag and the coming in the list. So you
pardon?
My lord, stay application was not been tagged in the original applications, my lord. This is the difficulty on the point.
When was it filed?
My lord, it has been filed just day yesterday, tomorrow, lordship.
No, then it will go before the single judge. Let us hear the the second appeal now under order 41. If you dismiss the appeal, then no question of stay.
I think, my lord, your logic cannot.
And if you admit the appeal, then we'll direct that to be listed before the 6 days delay in this matter also.
It has been, my lord.
Where is the section 5 application?
My lord, for that reason, we are seeking a clarification, your lordship, my lord. Your lordship, make it next, not this week, not this.
On the prayer of the appellant, let the matter stand adjourned for the week and be listed next on July 14, 2025.
So kind of lordship.
Thank you. Even next password.
36.
Yes,
my lord, sorry, my lord, I could not be present at that time, my lord.
No, you have to give a copy of the file at least to your junior. At least so that they can start, Mr. Chatterjee. You are sufficiently senior now. Yes, what is it?
Now, my lord, what happened, my lord? Unfortunately, my lord, the nephew, my lord, was allowed by the my lord maternal uncle, my lord, to stay with him in his house, my lord, and carry on his business, my lord, since my lord, it's 1978. Now, my lord, during the subsistence of the first marriage, my lord, there was a my lord acrimonious relationship. The maternal uncle married with the my lord present plaintiff, who is the respondent hearing. My lord, after the death of my lord the maternal uncle, my lord, the second wife, my lord, filed a suit for eviction against me as a licensee.
Maternal uncle was the owner?
Owner of the, admittedly.
You are the nephew?
I am the nephew, my lord, sister's son. Now, my lord, what happened, my lord, during the cross-examination, my lord, I put this question about the my lord subsisting of the first marriage. He said, yes, during the for subsistence of the first wife, my lord, she is the second wife. Now, my lord, both the courts, my lord, said, my lord, mostly, my lord, the appellate court has reasoned it out in the manner that in the written statement, I have taken a plea that only to the one-liner that she is not the owner of the property. Now, my lord, otherwise, there was no statement that there was first wife living and second marriage is void, therefore she cannot inherit after the death of the uncle. So, this issues, my lord, has been read by the appellate court, my lord, if my lord turns into, my lord, internal page 7 of the judgment, my lord, for which I have taken out an amendment application before the second appellate court as an abundant caution, because as an explanatory thing, well, why she is not the owner.
What is your defense in this? Only that.
My lord, otherwise, my lord, what happens if the first wife is now the owner? My lord, she is also the same status of a license. My lord, a licensee cannot evict a licensee. My lord, if the first wife now dies issueless, because they are issueless, my lord, then the property under Hindu Succession Act reverts
What
back
about
to
the
me.
whereabouts of the first wife?
My lord, she is living, but she has not been made a party here.
No, my lord. You have locus standi to challenge their marriage.
Now, my lord, if she in cross-examination admits to that extent.
Let us see what you are showing us.
My lord, internal page 7, my lord,
of the appellate court's judgment, my lord, 12.2. My lord will find, my lord, 5 lines bottom from the top of 12.2. The trial court, with all sincerity and surprising to note that the present appellant, being the defendant, has not whispered a single word in the written statement in support of his claim. The plaintiff Calcutta is the second wife of the deceased Shomunath Mondol, and their marriage was solemnized during subsistence of the first marriage of Shomunath Mondol with his first wife. Rather, defendant specifically mentioned in paragraph 9 of the written statement, and the plaintiff may be the legal heir of Shomunath Mondol but has no authority or ownership as alleged to the respect of the scheduled property. So, my lord, this is where, my lord, appellate court stops. My lord, there is no added pleading to that second marriage is void. And my lord goes on. Defendant within 4 corners of his has not written a single line specifying the fact that the deceased Shomunath Mondol has his first wife, or that the plaintiff is the second wife of the said Shomunath Mondol, or that the said Shomunath Mondol married second time with the plaintiff during subsistence of the first wife, and for that reason the plaintiff has no right to inherit the property of said Shomunath Mondol, since her marriage is void in the eye of law. Neither the plaintiff nor the defendant in the pleading have mentioned anything including the existence of first wife of the said Shomunath Mondol since deceased. It is the cardinal principle of law that a party relies on any fact upon which he bases his claim must plead those facts specifically, and also the onus lies upon him to prove those facts. In the instant appeal, though the present appellant placed the fact at the time of argument that the plaintiff was the second wife of the deceased Shomunath Mondol and she has no right to inherit the property of the said Shomunath Mondol, as the same is barred under the provisions of the Hindu Marriage Act as well as the Hindu Succession Act. But the defendant has materially omitted to incorporate these facts in the written statement and took no stand in this regard at any stage of the trial before the learned trial court, even by way of amending his written statement. Learned advocate for the present appellant defendant submitted that a party is supposed to adduce evidence depending on the issues framed by the learned trial court, and in the impugned suit, the learned trial court had not framed any issue in that regard, indicating that whether the plaintiff is entitled to inherit the property of Shomunath Mondol since deceased after his death, as his only legal heir being widow. The trial court reveals that the learned trial court had not framed any issue to that extent. Now, my lord, then on framing of issues, my lord, same thing. My lord, on this point also.
How did the trial court deal with it?
Well, the trial court most importantly has not gone into that, but kindly turns to internal page 5 of the judgment of the trial court.
Yes.
My lord, from exhibit 1, my lord has found from internal page 5. From exhibit 1, deed of partition such and such, it appears that Shomunath Mondol allotted co-scheduled property portion of the property which corresponds to a scheduled property of the plaintiff by this deed of partition. From exhibit 2, Shomunath died on 13/7/2005. The factum of death of Shomunath Mondol has not been denied by the defendant. Exhibit 3 and 4 corroborates plaintiff's claim of ownership of the scheduled suit property. Now, my lord, what are these exhibit 3 and 4, my lord, if my lord turns?
What are they?
Yes. These are, my lord, property tax receipts that my lord will find.
Better title than you.
My lord, property, my lord, tax receipt doesn't give any title.
Does not have to prove title to the hilt in a license eviction suit.
Now, my lord, finally visualizes if the second marriage is void, my lord, both are at the same pedestal.
You have not even pleaded that in the suit in the first appeal. You are for the first time in second appeal trying to amend your plaint.
No, my lord, I tell your lordship, my lord.
Why should we let you make out a new case here?
No, my lord, it's not about new case, my lord. I denied the ownership and title to the property.
That is very vague. That is very
now, my lord, what happened, my lord?
Government receipt and tax receipt prima facie shows that she was asserting her right in the property.
Yes,
she has a better right than you.
Now, my lord, kindly sees, yes, my lord has seen that. Tax electricity bills.
Yes.
Now, my lord,
this read on after that. It is pertinent to mention.
My lord, internal page 5.
After exhibit 3 and 4.
Yes, it appears
it is pertinent to mention.
Yes, exhibit 3 and 4 correct plaintiff claim ownership. It is pertinent to mention the defendant did not deny the fact plaintiff is the widow of deceased Shomunath, not defendant claim that exist other legal heirs of Shomunath. Now, my lord, this is where I join an issue, my lord. Suppose, my lord, upon death of Shomunath Mondol, my lord, the second wife doesn't get under as per law.
You are making out a new case.
Now, my lord, kindly visualize.
They were amended your plaint even in the first appellate.
Now, my lord, the law, my lord, if I may just say, my lord, after
law comes in only if you plead, Mr. Chatterjee.
My lord, just bears me for a minute, my lord. What I want to make out, my lord, say is that, my lord, suppose, my lord, there are factums, my lord, which both parties were aware, and my lord, parties have gone into cross-examination to that extent. Now, my lord, in that situation, my lord, even if there being no issue.
During your cross-examination, you said that in your chief, you have said that.
My lord, in cross of the plaintiff, my lord, she admits, my lord, she was crossed on this ownership.
During his cross-examination,
No,
defendant
Milord,
stated as DW1.
Yes.
It is a fact that I stated in my affidavit in chief that Kalpana is the
Is the
owner.
owner.
In your affidavit in chief,
nobody by oral admission cannot confer any ownership.
no.
Now, Milord, even if I say,
You're
Milord,
making
I'm
out a
owner of-
contrary case to you have in your chief you have stated that Kalpana is the owner.
Milord, this is where trial court, Milord, has not led into the cross of the wife, Milord, the plaintiff.
Why should it? You have in your affidavit in chief admitted Kalpana to be the owner.
A plaintiff must prove his case on its own plaint. Milord,
better title has been proved. That is sufficient in the
Milord, better
license.
title in my respectful humble submission today.
License
Milord,
eviction
both,
should, that is
both of us are in standing in the same petition being allowed by the Milord Shambhunath Mondal to stay in the residence. Milord, actual owner being Milord the first wife, Milord, upon the death of the first wife, Shambhunath Mondal being an issueless.
The first wife did not make any claim. No suit filed by the first wife.
It need not, Milord. On the death of the first wife, Milord, they being issueless, Milord, the property reverts back to Milord the sister's son, Milord, which is me. Milord, today I may not be there, tomorrow.
Good
Milord,
evidence
death.
in your affidavit in chief, you have admitted that Kalpana is the owner of the property. What else remains?
Milord, even for example, if I admit, Milord, that house to be myself of I being the owner, Milord, without Milord in operation of law, she doesn't become an owner. That is being admitted in her cross.
These are factual aspects, Mr. Chatterjee, not by operation of law automatically.
Only one
operation of law, it's not a pure question of law at all. It's a purely question of fact. It's a pure question of fact. At best, mixed question. Whether there was a subsisting first marriage or not, that's a pure question of fact. You never pleaded in the trial court, not in the first appellate court. You are making an amendment application in a second appeal, where the scope is so limited. No.
Now, Milord, to this, Milord, may I just...
And you admitted it in your affidavit in chief.
Milord, even if I admit to the extent, Milord, she is the wife of Shambhunath Mondal.
No, you have admitted that Kalpana is the owner.
And Milord, owner also, Milord. But Milord, in the same breath, in the written statement, I have said she is not the owner. That is
Sorry, Mr.
quoted.
Chatterjee. No interference.
Now, Milord, only one thing, Milord, Honorable Supreme Court says, Milord, in this type of cases, Milord, where, Milord, the issues, Milord, though not pleaded, but, Milord, parties are aware and cross has been done on that. Milord, this is an exception to the rule, where, Milord, court would take into account and, Milord, without framing an issue, court will divulge into that. And courts have divulged into that. Appellate court. Milord, there, Milord, my respectful humble submission today, this remains no more, Milord, a factum, Milord, for the court to disregard it, there not being any pleading. Milord, this is an exception to the rule. Milord, general rule is yes. What is
Yes, you are right. Issues, even if issues are not framed, both sides address.
Both parties are addressing.
Both sides addressed, you admitted her to be the owner and the widow.
Milord, but appeal at the same breath, Milord, in her cross, I have taken that point, Milord, and she answered the cross.
What did she say?
Milord, the first wife is available at that time, Milord, that is recorded in the appellate court's order.
Did she admit that she is the second wife during the subsistence of the marriage of the first wife? Shows that?
Milord, kindly takes up, Milord, that paragraph 12.2 of the appeal court.
12.2.
12.2, Milord, where I was reading.
Yes.
Milord, from that trial court.
Trial court.
Trial court with all sincere surprising to know the present appellant being the defendant has whispered a single word in the written statement in support of his claim. The plaintiff Kalpana Mondal is the second wife of the deceased Shambhunath, and their marriage was solemnized during subsistence of the first marriage of Shambhunath Mondal, which is verse 5. Rather, the defendant specifically mentioned in paragraph 9 of the written statement, plaintiff may be the legal heir of Shambhunath Mondal, but has no authority or ownership as alleged in respect of the scheduled property. The defendant within four corners of a written statement.
Mr. Chatterjee, even if a question is not in issue, an issue is not framed but the parties address, we can appreciate yes. But it has to be in the pleadings, has to be borne out by your pleadings. Not an owner is not a pleading, sufficient pleading. Marriage during subsistence of the first marriage is a specific pleading you have to make. And it's equally well settled that the court cannot look into evidence beyond the pleadings.
Well, this is where, Milord, I say, Milord, the exception has been carved out by Honorable Supreme Court.
That is settled, that even if an issue is not framed specifically, it can be dealt with by the
Milord,
parties.
Even there is no pleadings.
Shows that. And first show us the admission in cross-examination. You did not show us that.
Yes. Now, Milord, kindly. Now, Milord. Yes. Milord, kindly takes page number 8, internal page 8. One framing of issue.
Yes.
My lord, then, my lord, I'm not troubling with that page. Kindly turns over. Page 9. And the defendant further has not taken a positive plea in his pleading, and the plaintiff has no right to inherit the death of Somunath Mondal, since the plaintiff got married with Somunath Mondal during subsistence of first marriage. Now the question is whether this court will look into evidence of PW1 plaintiff in this regard, in spite of the fact does not find any place in the pleading of the defendant who intends to rely on it.
Can evidence be looked into without pleading?
My lord, this, my lord, just
Cite the judgment. Let us see that.
Well, I try, my lord, to because this is, my lord, a nephew, my lord, and mama, my lord. Where, my lord?
Ideal relationship. Yes.
My lord, mommy is throwing me out.
If I had a nephew like you, I was the mommy, I would have thrown you out. You're dragging us to court. Rather, they dragged you to court here. You're right. Yes, which paragraph?
Paragraph 17 kindly turn.
17, yes.
Judgment letter. This is reported in 2008, volume 17, Supreme Court cases 491. It is thus clear that a case not specifically pleaded, my lord, got it, my lord?
Yes.
Can be considered by the court only where the pleading in substance, though not in specific terms, content necessary to make out a particular case, and the issues framed also generally cover the question involved, and the parties proceed on the basis that such case was at issue and had led evidence thereof. Well, this is this exception. Well, an issue.
What were the facts of the case? What was the pleading there?
Lord, pleading paragraph 9 of the written statement, and there are other.
No, here in this case.
Well, in this case.
In the reported case.
My lord, here, what happened, my lord? My lord, here, kindly takes up paragraph 7. In High Court, what happened, my lord? An easementary right of passage was claimed, though not specifically pleaded, of easementary right. No specific factum of easementary right, but in evidence, the right of user was, my lord, brought into force. My lord, subject to correction, my lord, the facts.
Here it was held otherwise.
So in this my lord held otherwise, but my lord 17 my lord carves out that exception. My lord might be my lord the factually my lord it has gone otherwise, but here my lord I am on the exception which Supreme Court has carved out. My lord, in a case my lord where one of the issue was whether she is entitled to the property and my lord eviction. My lord there my lord where one liner of not being owner and an evidence on that line being gone into, parties were aware of this, that ownership is one of the my lord pleadings my lord which is an issue. My lord might not be framed, but from defense and my lord plaintiff my lord this was one of the issues. There my lord I say I take out this exception which my lord Honorable Supreme Court has carved out my lord in this case. In such situation where basis is their ownership, my lord, if had it been a case, my lord, in the written statement, I have not even stated the factum of disputing the ownership. My lord, my basis would have gone. My lord, today if I come with an amendment application, I would have taken an argument that is an explanation to the basis of denying the ownership.
No, Mr. Judge. The present second appeal has been preferred against the judgment of affirmance, comma, at the behest of the defendant stroke licensee. Push up next para. Learned counsel for the appellant argues that both the courts below failed to take into consideration the fact that the plaintiff, comma, claiming to be the wife of the original owner, comma, who was the maternal uncle of the defendant stroke appellant, comma, was the second wife of the original owner during subsistence of his prior marriage. Full stop. Next para. It is submitted that although in the written statement, comma, it was specifically pleaded that the plaintiff was not the owner of the suit property, comma, both the courts below failed to take into consideration the fact of the marriage of the plaintiff with the original owner being void due to subsistence of the previous marriage. Push-up learned counsel argues that although there was no specific pleading as to the plaintiff being the second wife during the subsistence of the first marriage of her husband, comma, the original owner, comma, the rudiments of challenge to ownership was there in the written statement, full stop. It is contended that even if there is no specific pleadings, but the basis of the primary pleadings are found in the written statement, comma, the courts, comma, despite issues not being specifically framed, comma, can decide on the issue if both parties address such issue at length and adduce evidence thereon. Full stop. Next para. Learned counsel places reliance on such and such নামগুলো দিয়ে দেবেন, reported at 2008-17 SCC 491, where the Supreme Court observed, comma, inter alia, that a case not specifically pleaded can be considered by the court only where the pleadings in substance, comma, though not in specific terms, comma, contain the necessary averments to make out a particular case, and the issues framed also generally cover the question involved, and the parties proceed on the basis that such case was at issue and had led evidence thereon. Full stop. It was held that as the very requirements indicate, comma, this should only be in exceptional cases where the court is fully satisfied that the pleadings and issues generally cover the case subsequently put forward, and that the parties being conscious of the issue had led evidence on such issue. Full stop. Next para. It is further submitted that the PW1, comma, in her evidence, comma, virtually admitted about the subsistence of the first marriage during at the point of time when she contracted marriage with the original owner, which was not looked into by the courts, by both the courts below. Next para. However, comma, we are unable to agree with the submissions of learned counsel for the appellant for the following reasons. Colon diye niche. The proposition sought to be portrayed to have been laid down in the cited report was in the specific context that a case not specifically pleaded can be considered only in exceptional cases where the court is fully satisfied that the pleadings and issues generally covered the case subsequently put forward, and the parties being conscious of the issue had laid evidence on such issue. Full stop. Apart from the fact that there is a concurrent finding of both the courts below regarding dissatisfaction that sufficient pleadings were there for the purpose of leading evidence on the issue of the marriage of the plaintiff being void, comma, we also find from the records that the issues framed did not even cursorily touch the question of subsistence of the prior marriage during the and at the point of time when the plaintiff got married to the original owner. Full stop. The only two questions which could come near the same were the first issue, comma, which is whether the suit is maintainable in its present form, and the second issue as to whether the plaintiff had any cause of action to file the instant suit. Full stop. Next para. However, comma, such issues are too vague and general in nature to prompt the court to come to a conclusion that the same gave sufficient notice to the plaintiff about the point sought to be argued by the defendant stroke appellant now. Full stop. Next para, that apart, comma, the courts below considered the evidence at length. Full stop. Particularly, the learned trial judge came to the specific finding that the defendant stroke appellant, comma, in his evidence as DW1, in his cross-examination as DW1, comma, admitted that he had stated in his affidavit in chief that Kalpana Mondol, comma, the plaintiff stroke respondent, is the owner of the suit property. Full stop. It is further recorded by the trial court that the defendant also stated in his cross-examination that he does not know exactly whether Shambhunath Mondol executed any will in his favor, comma, despite him having sought to run a case that there was a will executed in his favor. Full stop. Next para. It is also recorded by the learned trial judge that the defendant stroke appellant did not deny the fact that the plaintiff is the widow of deceased Shambhunath Mondol, comma, the original owner, nor did the defendant claim that there exists other legal heirs of Shambhunath Mondol. Full stop. Next para. Thus, comma, since the defendant stroke appellant himself admitted that Kalpana Mondol is the owner of the suit property and did not deny that the plaintiff was the widow of the deceased original owner, comma, it does not now lie in the mouth of the defendant to resile from such position and place reliance on the pleading in his written statement in a vague manner that the plaintiff is not the owner of the property. Full stop. Next para. The appellate court was justified in observing that the court cannot look into the evidence of PW1 with regard to the subsistence of a prior marriage at the time when she got married, comma, since the issue did not find place in the pleadings at all. Full stop. Next para. Although it is trite law that even if specific issues are not framed, but both parties go into trial knowing fully well the issues involved and adduce evidence thereon, comma, the courts can decide on such issue, comma, the said principle is diluted in the present case in view of the pleadings having not specifically mentioned anything about the subsistence of a prior marriage at the point of time when the plaintiff married her husband, and stroke or even as to the marriage of the plaintiff with her husband being a nullity or void in the eye of law. Full stop. The bare mention of the plaintiff not being the owner of the property is absolutely blanket and omnibus in nature and cannot comprise of the rudiments of the pleading that the plaintiff's marriage was void, comma, for which she was not the owner of the property. Full stop. Next para. Even in the cited report, comma, the Supreme Court ultimately came to the finding that the pleadings necessary to establish an easement by prescription, comma, as required therein, comma, were not found in the pleadings of the parties. Full stop. Next para, the Supreme Court reiterated that in the absence of a specific claim by the plaintiffs based on an easementary right, the first defendant therein did not have an opportunity to demonstrate that the plaintiffs had no easementary right. Full stop. As in the said case, in the present case, the defendant merely touched the issue of the plaintiff not being an owner without pleading anything regarding her marriage being void or there being a prior marriage subsisting in respect of the owner at the time of the second marriage with the plaintiff. Full stop. Rather, the defendant, in his evidence, admitted that the plaintiff was the owner of the suit property and never denied that the plaintiff was the widow of the deceased original owner. Full stop. Next para, it is also noteworthy that in neither of the courts below did the defendant appellant take out any application for amendment of his plaint to incorporate such pleadings. Full stop. For the first time in the present second appeal, such an application has been made. Full stop. Next para, however, it is well settled that the limited scope of factual consideration by the appellate court, by the second appellate court, is circumscribed by section 100, read in conjunction with section 103 of the Code of Civil Procedure, and no question of fact can be permitted to be raised for the first time unless it directly pertains to a substantial question of law, which is already available from the materials in the courts below. Full stop. Thus, we do not find even the rudiments of any pleading challenging the marriage, challenging the validity of the marriage of the plaintiff, and consequentially her not being the valid wife of the owner. Full stop. Furthermore, we find from the records that the courts below relied on exhibits 3 and 4, which are receipts produced by the plaintiff stroke respondent to the effect that government rent and tax was paid in respect of the suit property by the plaintiff stroke respondent. Full stop. Thus, at least the plaintiff had a better title than the present defendant stroke appellant, which was established before the courts below. Full stop. Next para. In such view of the matter, the cited judgment does not help the appellant in any manner. Full stop. We do not find any question of law, rather any material basis in the pleadings to give rise to such question of law, which was regarding which the plaintiff was sufficiently put on notice by the defendant at the relevant point of time prior to trial. Full stop. As such, there is no occasion for us to interfere with the concurrent findings of fact of both the courts below. Full stop. Hence, since no substantial question of law is involved, SA 16 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Full stop. In view of our above observations, can 1 of 2025, seeking amendment of the written statement at the second appellate stage, is also dismissed without any order as to costs. Next. Sorry, Mr. Chair.
I am for the appellant, my lord.
Please.
Judgment against affirmation. Plaintiff is the
Affirmation.
affirmation.
You are the defendant.
Plaintiff is the appellant before lordship.
Defendant.
No, plaintiff is the appellant.
Plaintiff. Sorry.
My lord, before that I am submitting, my lord, there's a defect. Some, my lord, signature of the trial court does not bear in the decree.
We'll send it to the trial court after hearing you.
Now, my lord, after that, my lord, the law point is that whether a person has any title over the property by virtue of a registered deed of sale, while the same property has been transferred from the original landowner to the present vendor of the plaintiff, not being placed before the learned court. I mean,
we do not understand. Please just.
My lord, I am explaining. One Shupal Bhandari and Rajbiri Bhandari, two brothers. 95 decimals of land they possessed. 48 Shupal, 47 Rajbiri. Shupal Bhandari in the year 1967, 15th September 1967, transferred 33 decimal of land to one Ashutosh Dattu.
It was a demarcated portion or
Demarcated portion. Most probably demarcated, may not
maybe
be.
share, maybe yes.
Share. Thereafter, Ashutosh Dattu 1980 transferred the same to another person, Nilima Shandal. And in 2011, Nilima Shandal transferred the 33 decimal to the applicant number 1. The matter is there. Now, 5 decimal of the same plot of land has been transferred to another person.
By the same vendor?
By the same vendor, Shupal Bhandari. And therefore, from that person, I mean, who has been purchased from Shupal Bhandari.
5 decimal from the same portion which was sold to you?
Another portion.
Yes.
Shupal Bhandari was 48 decimal, 33 first, then 5 decimal. That also purchased by the applicants. Again, in 12 December 67, same year, this has been done in 15 September 1967 and 12 December 1967, he transferred again 31 decimal to the respondents. When he has only 40 decimal capacity, I mean owner.
If he already sold that, he could not have sold that again.
Again, remaining portion. After selling 30.
Remaining portion he could have sold?
No, remaining portion 10 decimal left. First 33, then 5.
No, in September he sold to your vendor's vendor.
Vendor's vendor.
How much? 33?
33 plus 5.
Plus 5.
38. 38. 33
30,
plus 5,
30.
38.
But he again sold 31 from the same portion to someone else in December.
Not same portion.
Different.
Excess. From his brother portion. Brother held 47, he 48. So after 38, he again sold 31. Now, his brother Rajbari was bachelor. He died issueless. Therefore, my lord, after death of Rajbari, his portion devolves upon the sons of Shupal Bhandari. That is the first vendor. The present appellants purchased that 47 Rajbari from the legal heirs of Shupal Bhandari. Now this opposite party respondents claiming that I am the owner of 31 decimals of land, and we are claiming we are 33 plus 5, 38 plus 47, 95, 85 decimals of land. Total area is 95.
But if he sold that 47 to them, how can you claim right over that?
47 purchased by us, my lord. 47 decimals purchased by us from the legal heirs of Shupal Bhandari. His brother died, he was bachelor, died intestate.
After that, they became owner? And
yes. Now,
what is their claim?
Their claim, they are saying we are 31 decimal of land owner. Other side.
Who are they?
They are the respondents. Number
they
1.
Purchased from whom?
Purchased Shupal Bhandari. Shupal Bhandari. Shupal Bhandari sold the property to one Swadesh Ranjan Vishwas. You will also kindly consider this is a chart I have prepared.
That will be better.
This is complicated, man. I have given chart.
Very.
First, you can see left hand side, Shupal Bhandari 8 anna share, that is 14 decimal.
1 8 anna is 48 and another 8 anna is 47.
47. 14 and 47. Total is 95. They decided 47 and 48. Otherwise, it should be 47 and 5 each. Now, Shupal Bhandari transferred by virtue of deed of different buyers, sold to Jogeshwar Sarkar on 15 September 1967. Then sold to Nilima Dattu, deed number 1972. Then 30 decimal to Kamalakanta. That is applicant number 1.
So you say you have purchased from both sides?
Both sides.
Rajbari's side and Shupal's side?
Lordship.
What is their claim? They say?
They say they purchased from Shupal Bhandari, 31 decimal. In the year 1967, month of December. That is after my purchase of vendors.
That is what we are saying, that if they purchase on 31st December.
31st, 30th, 12 December.
12 December.
1967.
67.
Yes.
At that point of time, Shupal did not have any title in respect of that because he had already sold.
Lordship. Only 10 decimal left. Only 10 decimal left.
10 decimals.
But he sold 31 decimal.
At least 21 was extra.
Yes, my lord. And it is evident from the record of right, those purchases.
What is the suit you filed?
Suit for declaration of title and injunction not to disturb my position by the respondents.
But regarding that 10 decimal, they could have right.
Yes. Yes, that is the thing. 10 decimal, we have right. We have no objection. But they are claiming 31 decimal.
But you are claiming right over the entire property, including that 10 decimal also.
No, not excepting 10 decimal.
You have accepted that. Why did you lose in both the courts?
Because learned court is of the view, I have to produce all the certificate copy from Shufal, then Jogeshwar, then Nilima Datta. Otherwise,
You produced up to which stage?
My vendor, that is Nilima Datta.
Nilima Datta, in her deed, the entire narrative was given.
Yes. The federal question, internet has been given. But learned court says no, you have to file the certificate copy of Jogeshwar, then Nilima.
No, the difficulty here is unless you produce the previous, because they claim from Sufal directly. They must have produced the Sufal's sale deed.
Yes. They claiming from
So the
Sufal.
dispute starts not from your vendor, starts from Sufal's, time.
Lordship. Now,
So unless you produce Sufal's transfer deed, how can we be sure? I mean, the courts can be sure.
Point is that, my lord, they did not challenge my deed. They are saying they're 31st, they are owner of 31 decimal. We are saying we are 94, 90, 85 decimal. Now, so far as our 33 decimals from Shufal and others, and thereafter, my lord, 47 decimals from the legal heirs of Shufal, it cannot be said that I have to produce all the certificate copy from the previous one.
They purchase only 731.
31.
So regarding the other portions of the suit property, at least you had to have right. They are not claiming right even regarding the other portions apart from 31.
No, not apart from 31. They have only claiming 31. But at that relevant point of time, Shubal Bhandari has the right to sell out 31 decimal. Only 10 decimal left.
But for showing that, you have to show that Sufal had sold the property. You have not produced Sufal's sale deed to Jogeshwar.
My lord, it is decided
Because your case is based on at that point of time. Your case starts from there. Not your purchase is different. Just because your vendor has mentioned that she has purchased does not mean she had purchased. Now, you raise a dispute that no, Sufal had already, since Sufal had already sold a majority portion, they could not have purchased 31. But for that, you had to produce the sale deed of Sufal. Courts are right.
My lord, in the residual portion of my vendor's deed, it has been categorically stated deed number, year, date, everything is there.
Why didn't you sought for production of those deed numbers and all those things from the registry?
At that point of
You
time,
could have.
it was the old deed, my lord. It was not in the possession of the
The possession, yes, deed number is given. You could have just produced those documents. From the registry office, you could have produced some paper.
Subsequently, occupied. It is with me, my lord. Subsequently, got it. But at the relevant point of time, they could not.
Before both the courts believe you did not produce, and now in the second appeal for the first time, why should we permit you? You are barred by order for Rule 27.
But my lord,
at least regarding, you could have produced in the first appellate court. If you produce in the first appellate court, refuse, then we could have understood. For the first time in second appeal, you cannot produce.
But my lord, only one point that when residual portion is categorically stated, I asked.
Now you have got the Sufal, the deed of Sufal.
Yes, my lord.
You have got Sufal's deed, Sufal's transfer deed.
Yes,
September deed.
September deed.
You have filed an order for Rule 27.
I'm waiting. If your lordship allow me, I can, with the leave of the court, I can file it. This is the second appeal stage, my lord. That's why.
How can you do that? You did not take that point in either of the courts below.
Did not take, my lord. So if for my second appeal, my lord, if your lordship allow me to.
Please take your seat. You don't have a right of hearing.
At this stage, my lord, if your lordship allow me to file 4127 because it's not admitted yet. That's a difficult element because residual portion categorically stated everything. There's no doubt that is, they did not challenge it, my deeds, sir. They're saying they were not 31 decimals. So my.
You file that order for Rule 27, then come back. We are not assuring that we will admit the appeal, but we can at least look at the deed and take a decision.
Lordship.
The plinth of the submission of learned counsel for the appellant is that both the courts below erred in law in insisting upon production of a deed of 1967 executed by one Sufal, Suphal, Bhandari, Vaideshesh, Bhandari, who was the original vendor of the line of purchase of the plaintiffs. First of it is submitted that the purchase deed of the plaintiff and the plaintiff's vendor clearly indicate that Sufal Bhandari sold a substantial portion of the property in question in favor of the vendors of the plaintiff's vendors. First up, as such, the plaint case was based on Sufal having no title left to transfer 31 decimals to the defendants, which is the premise of the title of the defendants. First up, however, we find that the insistence of the courts below on the production of the deed of Sufal was not entirely unlawful, since the dispute relates back to the dates of transfer of Sufal, which are respectively of the month September in the year 1967 in favor of the grand-vendors of the plaintiffs, and in the month of December 1967 in favor of the defendants. Learned counsel for the appellant, during hearing under Order 41 Rule 11 of the Code of Civil Procedure, submits that he is now in possession, in custody of the deed of sale executed by Sufal at the relevant period, on which the decision of both the courts below hinged. Next para, without expressing any opinion on whether such deed can be looked into at this stage, on the prayer of the appellant, we permit the appellant to file an application under Order 41 Rule 27 of the Code of Civil Procedure for seeking production of the said relevant deed executed by Sufal in favor of the grand-vendors of the plaintiffs. How soon can you file that?
Within 2 weeks, my lord.
Accordingly, let the matter go out of the list for the present, with liberty to the appellant to mention the appeal for inclusion in the list for being listed under the heading Order 41 Rule 11, along with the application for production of additional evidence, as and when so filed.
Deeply obvious.
Thanks. We have recorded everything. Just show us this order on the next day.
Lordship.
But we are not assuring you that we will admit it. We will consider the question whether Order 41 Rule 27 A prevails or B prevails.
Lord, the advocate of the petitioner is suffering from high fever, so she could not attend.
He is suffering from high fever.
Advocate on record.
Who is the advocate?
Mizanur Rahman.
Mizanur Rahman. You are also there in this matter.
No, I'm not.
I appear for opposite party ban. There is no scope of stay because the title.
No scope of?
Stay. For stay.
First, let us admit the appeal. We have not yet admitted the appeal. If you dismiss the appeal, that there is in any way, but the deficit court fees are there. You have to do those things. There are several defects. Please ask Mr. Rahman to rectify those. An adjournment is sought
for 1 week.
On behalf of the appellant, the learned advocate on record for the appellant is directed to carry out the necessary corrections to remove the defects in terms of the report of the additional stamp reporter. Within a week from date, let the matter be posted for hearing under the same heading on July 16, 2025. Please carry out the corrections within, ask him to carry out the correction. Give your name only today.
I appear
Yes.
for appellant, my lord.
Yes, Mr. Vanitz.
My lord, against the judgment of reversal, appellant is the plaintiff respondent.
What is the defect first? Defect.
Trial court order.
In the trial court order, my lord, trial court decree, there's some lord mistake in the names, but the
that you cannot.
decree of the appeal court, my lord, tallies with the my lord cost.
It has to be sent down. Yes.
It has to be
So judgment of reversal, you are the plaintiffs.
The plaintiff, my lord,
suit for
eviction under Premises Tenancy Act. Trial court, my lord, decreed on the ground of reasonable requirement as well as my lord default. Appeal preferred. Appellate court not held all the issues in my favor, but so far as the issue of service of notice, appellate court held that I failed to prove service of notice. Now, 2 grounds. First ground is that in the written statement by the original defendant died during pendency of the suit. Original defendant filed a written statement where in very many terms he has not said that notice was not served upon me. The paragraph, there was only vague denial. The statements are denied, matters of record. No statement that it is not served. Notice is not served.
But you cannot rely on their written statement.
No. So at least
circumstantially one.
Circumstantially
Yes.
one.
But how
second, what I filed is not the eviction, the notice along with not the postal track report, postal receipt and the track report. I filed all 3. Now the track report, although it was taken on record by the trial court, but it was not marked as an exhibit.
So order 41 rule
I have
27.
filed one application for order 4127 also in this. In the appeal court, I have not filed.
Rule 27A.
27A.
A.
Filed but not.
Filed but not.
And the
Is it-
trial court has considered that also because the track report says it is duly served, but the postal receipt, the PIN code was incorrect. Although it was served, because track report shows, but the track report was not exhibited because it was not no certificate under 65B was given by the before the trial court. Possibly that is why it was not marked. But nothing is recorded.
Nothing is recorded.
So this is the order, my lord. Kindly see, my lord. Attach it. Kindly see, my lord. Question number 6.
Yes.
I have filed before this court.
Let the copy be marked as exhibit, but it was
Yes.
never marked.
Copy of the notice and postal receipt be marked as exhibit 3 and 3A.
Yes.
But, my lord, the track report was not marked. Notice,
Postal receipt.
notice,
No, notice and postal receipt were marked.
were marked. But the track report was not marked.
That also gives rise to presumption if it was at the correct address.
No, the PIN code was not correct.
Oh.
PIN code was not correct. But the track reports shows it was served. Track report shows served to the address. But this was not marked as an exhibit. Now the appeal court has gone by the. But the issues are held in my favor. That
notice আর postal receipt টা mark করেছে exhibit 3 and 3 ওরই ভুল examination chief I have filed before this court copy of notice to quit along with postal receipt and track report. Bracket হচ্ছে let copy of notice and postal receipt be marked. Track report টা ছেড়ে গেছে.
it is not part of the application for additional evidence can 1 if a lordship is that track
Yes,
report.
order 27 has to come.
65B certificate was not given at that point of time. That is the
This second appeal will be heard on the following substantial question of law: whether the learned judge of the first appellate court substantially erred in law in overlooking the provisions of order 41 rule 27 within bracket 1 within bracket small a of the code of civil procedure in holding that arriving at the conclusion that the plaintiff stroke appellant has failed to prove the service of notice of eviction under section 6 of the West Bengal Premises Tenancy Act 1997 by overlooking that the track report regarding service had been produced tendered at the time of evidence but was erroneously not admitted erroneously not marked as exhibit. Push up next, whether the application for production of additional evidence filed before this court ought to be admitted and consequentially, an opportunity ought to be given to the plaintiff stroke appellant to prove in accordance with law the track report in respect of service of notice of eviction on the defendant stroke respondent. Next para, whether the learned judge of the first appellate court substantially erred in law in reversing the decree of the eviction decree passed by the court of first instance, despite having concurred with the findings on the grounds of eviction with the learned trial judge, but dismissing the suit on the sole ground of the service of notice to quit having not been proved, without directing the track report filed in evidence by the plaintiff stroke appellant to be marked as exhibit. Yes, no question of any interim order. The appellant shall put in postal costs. Acha na, tar age ekta kore dao. Can 1 of 2025 shall be heard along with the hearing of the appeal, full stop. Affidavits, if any, shall be exchanged in the meantime. The appellant shall put in postal costs and due requisites for service of notice of appeal on the respondents within a week from date. The trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within a week. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal before the appropriate learned single judge having determination at the relevant juncture for inclusion in the list for hearing. As and when the same is ready for hearing.
Obliged, my lord.
Thank you.
My lord,
Yes.
I am for the appellant. My lord, I pray let the matter be taken up tomorrow because affidavit service has not been ready, my lord.
On the prayer of the appellant, let the matter stand adjourned for the day.
I am for the appellant, my lord.
You are for the appellant. How are you? How are you, Mr. Banerjee? Yes, long time. Yes, what is the matter?
44. My lord, defect TVs
Defect. This is item 44.
44. Defective.
Ardhan Banerjee appeared. Ardhan Banerjee number.
Trial court judgment and degree has not been filed to save limitation at the time of filing. And second, spelling mistake, name of the respondent number 1, 2 defect.
আচ্ছা ইয়ে অনিন্দিতা আগেরটা নিলে তুমি অয়নেরটা অয়ন ব্যানার্জিটা ওটা একবার ফাইলটা দেখে নিও তো একটা ডিফেক্ট আছে বোধহয় file be sent down to the trial court for carrying out necessary rectifications in the trial court's decree. তুমি একবার তবু দেখে নিও ডিফেক্টিভ আছে কিনা এটা থাকলে এটা করে দিও yes sorry Mr. Banerjee, we had missed out something in the previous order, that is what it is. First name of sole respondent, yes, what about that? First, so we'll give you leave to correct, one. Secondly,
Trial court judgment and degree, certificate copy of trial court
degree have not filed.
Not been filed to save limitation at the time of filing.
So we'll give you some time to file that.
Has already been filed subsequently.
Very well. We'll take up the appeal for hearing under order 41. You are ready for order 41 hearing? We will just record one line. Leave is granted to the learned advocate for the appellant to carry out the necessary correction to the cause title of the memorandum of appeal insofar as the first name of the sole respondent is concerned. Such correction shall be carried out during the course of the day. The next para, learned counsel for the appellant submits that the certified copies of the judgment and degree of the trial court have since been filed. Full stop. Accordingly, the office is directed to furnish a revised report in that regard. Full stop. The appeal is now taken up for hearing under Order 41 Rule 11 of the Code of Civil Procedure. Yes.
On 18th June 2025.
আচ্ছা যেখানে ট্রায়াল কোর্ট এটা ফাইল বলেছি on June 18, 2025. Trial
2025.
certified copy of trial court. Yes. What is the matter?
My lord, here defendant is the appellant, suit for eviction, judgment of affirmance. My lord, this submission, my submission is that this suit is not maintainable in its present form because no relationship of landlord and tenant was created between the parties.
Why do you say that? Why do you say that?
Because, my lord, in the plaint, there is no mentioning who has inducted the defendant. Defense.
They have claimed to be the owner. The plaintiff has claimed to be the owner.
Who has inducted the defendant has not been mentioned.
If they are the owner of the property, they have a right to evict you.
At that time of induction, plaintiff was not an owner of the property. Plaintiff's father and mother purchased the property.
Subsequent owner cannot maintain an eviction suit. Then, if the inductor dies or transfers the property, the subsequent purchaser will never be able to evict you.
Plaintiff and his sister.
Yes.
Persons. No letter of attornment has been given to the.
One of the co-owners have filed the eviction suit.
No letter of attornment has been given.
Need not be given.
During the lifetime of the plaintiff's father, plaintiff collected rent.
Maybe, but at the time when the suit was filed and was decreed, that is a relevant point of time, plaintiff's father was still alive.
No, my lord, after
Then
demise, after
the plaintiff,
demise,
plaintiff became the owner of the property. At least the co-owner, co-owner can maintain a suit for eviction.
my lord,
No point, Mr. Banerjee. The present appeal has been preferred against a judgment of affirmance. First of both the courts below have granted an eviction decree against the appellant under the West Bengal Premises Tenancy Act 1997. First of next para.
Under the TP Act.
Under the Transfer Property Act. Achha. Under the Transfer Property Act 1882. First of next para. Learned counsel for the appellant argues that there was no landlord-tenant relationship created between the plaintiff and the defendant. First of, although the plaintiff collected rent, the same was during the lifetime of his father, who was the admitted owner at the relevant point of time. Full stop. Furthermore, upon the demise of the plaintiff's father, it is argued that the plaintiff as well as his sister became co-owners of the property. Full stop. Moreover, in the absence of any letter of atonement, the suit was not maintainable in its present form. Full stop. Next para. However, it is not the law that the subsequent owner, who acquired the property by virtue of inheritance, cannot maintain a suit for eviction, although the said subsequent inheritor did not originally induct the tenant. Full stop. Moreover, a letter of atonement is not a sine qua non for the purpose of maintaining a suit for eviction by the current owner against the lessee. Full stop. Next para. Thirdly, it is well settled that a co-owner is an owner in equal rights, and as such, there is no bar in a co-owner maintaining a suit for eviction against a lessee, provided, of course, it is not proved by the defendant that the other co-owner categorically disagrees to the filing of such eviction suit. Full stop. In the present case, no such case was even made out by the defendant stroke appellant to the effect that the alleged co-owner of the property registered the filing of the eviction suit by the plaintiff. Full stop. Thus, we do not find any substantial question of law involved, nor do we intend to interfere unnecessarily with the concurrent findings of facts by both the courts below. Accordingly, SAT 120 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Can 1 of 2025 stands disposed of accordingly. No order is to cost. Please carry out the correction, but to the yes. Thank you.
Item 45, my lord, I am appearing for the appellants.
Yes,
Kindly excuse me, my lord, for appearing virtually.
No
My lord,
difficulty. Yes.
defendants are the appellants before your lordship in a suit for eviction of licensee. My lord, this is a judgment of affirmance.
Right.
I tell your lordship, my lord, during pendency of the appeal, my lord, I filed an application under Order 41 Rule 27, annexing a document from which, my lord, it is evident that the property on which the building is erected and my lord, situated has been, my lord, acquired by Government of West Bengal in 1980-81 from the vendor of the respondent plaintiff. Vendor, my lord, initially in the plaint, my lord, they have said that only 1,444 square link property has been sold out to the vendor of the plaintiff out of 25 decimals. But the document from which, my lord, document issued by the Government of West Bengal, from that, my lord, it is evident that out of 25 decimals, 23 decimals has been, my lord, acquired by Government of West Bengal. So it's not a case that only 1,444 square link land has been sold out to the school. The entire property has been sold out to the school, and in 1980-81, my lord, 23 decimals has been acquired. Now the plaintiff in his plaint, Milord, has not described the property properly. Kindly takes appeal court's judgment, page 4, Milord, paragraph 7, appeal court's judgment. What I have submitted, then I will take your lordship to the finding of the court, where the court is saying even if the construction is made on encroached property, that is not to be looked into by the government. That means, Milord, if the government's land is encroached and Milord, construction is made there, that is not the lookout of the government. Now, Milord, kindly takes paragraph point number 7 in the of the appeal court's
Yes.
judgment.
Yes, we are there.
During the course of hearing of this appeal, appellants filed an additional written statement with the petition under Order 8, Rule 9 of the Civil Procedure Code, and another petition under Order 41, Rule 27 of the Code, praying for additional evidence. The contention of the appellants behind the filing of those two petitions is that after the disposal of the instant suit under appeal, they came to know the existence of LA case number 134 of 1980-81, wherefrom they came to know that the plaintiff respondent has no interest as right over the suit property due to the acquisition of the land, acquisition of the said property by the government by virtue of that case. It is contended that the plaintiff is stopped from claiming ownership over the suit premises by virtue of this said case. The petition under Order 14, Rule 27 of the Code
So, Mr. Rai, the LA case was filed by the plaintiff or his vendor?
Plaintiff was not there. The plaintiff, as per the plaintiff, Milord, plaintiff purchased the land in 1993.
Plaintiff's vendor filed that LA case for compensation.
No. Plaintiff's vendor, Milord. Plaintiff's vendor. Because Milord, as per plaintiff, Milord, in 1957, the property has been sold out to plaintiff's vendor, the school. Now, Milord, the petition under Order 14, Rule 27 of the Code was heard with this appeal and is considered and decided in this judgment in appeal. Learned advocate, Milord, this is important. Learned advocate for the appellants during the hearing of the appeal submits that the suit premises are situated on plot number 135, which is a two-storied building. But from the description of the suit premises in the schedule of the plaint, it is not at all identifiable and visible, and therefore decree is not executable for its vague description. It is further contended that the plaintiff purchased 1,444 square link from the Hanschora school and a two-storied building on 1 decimal of land, which is equal to 4,355 square link of land, cannot be constructed, and the plaintiff must have encroached on the property vested in the state. It is further argued by the landed counsel for the appellants that the plaintiff disclosed that the defendant number 1 has to collect rent from other tenants, and there cannot be any such clause in the license agreement he averred by the plaintiff. He has admitted that they were relatives, and since 1st May 2012, the appellants have been in possession of the suit premises and discussed the importance of paragraph 6 of the plaint over the necessity of an agreement between the plaintiff and the defendant number 2, who is the wife of the defendant number 1. Now, Milord, kindly takes point number 16. Of the appeal court judgment, how, Milord, this acquisition has been dealt with.
Yes.
During the course of argument, the learned advocate of the appellant raised the question on the right, title, and interest over the suit premises, relying on certain documents he got from the LA case referred by him. This is a suit for eviction of a licensee. It is the plaintiff to prove his case. If the defendant has a case, he has to file a counterclaim. The defendants filed separate suits claiming tenancy rights, but it was not prayed to be heard together with this suit, although both the suits were pending in the same court. Section 116 of the Evidence Act states that the tenant has no right to deny the title of the landlord. Whether the suit premises was constructed on the vested land or not is the lookout of the government, as the defendants have no right to raise the question over the right.
Mr. Rai, how do you get over section 116? You are admittedly inducted by this person.
I was, but Milord, point is, without holding an without holding an inspection under Order 13 and Rule 7, where, Milord, the right of the property.
But Mr. Rai, you are stopped under section 116 from taking this point.
Kindly, Milord, kindly consider this document was not in my Milord custody during pendency of the suit. I got it during
it's not a question of this document being in your custody. Even if this document was in your custody, Admittedly, you were inducted by the present plaintiff.
I was inducted, Milord, as a tenant. Now there is no license agreement nor, Milord, any tenancy agreement.
Tenancy you have failed to prove.
Court, Milord, kindly see, appeal court considered me as a tenant, not as a licensee. Considered me as a tenant. Kindly read the rest of the portion. And the defendants have no right to raise the question over the right, title, and interest of the landlord licensor of the suit premises in the suit. For that reason, there is no necessity to produce any additional evidence for the proper disposal of this appeal. Now, Milord, after that, Milord, court has proceeded that the document is not admissible and the document is not, Milord, admitted in evidence. The point is, Milord, if the plaintiff, Milord, is silent about the acquisition, and, Milord, if a wrong statement
Mr.
is
Rai, you
stated,
are barred by section 116. However good a case you may have regarding acquisition, but your case is, you are
116, that is
it
there,
stares
Milord.
at your face and you cannot overcome that.
That is
You
absolutely,
cannot
that is
challenge the
absolutely.
title. The entire
I
world
have
can,
challenged.
but
No,
you.
I have, Milord, I have a previous suit in which, Milord, the my tenancy right has been, Milord, claimed. Now, Milord, point is, Milord, whether they have exact what portion of the land they have purchased, that is not clear from the plaint. I have, Milord, annexed the plaint in the stay application. My lord will see. My lord kindly takes the stay application and the plaint. The plaint is vague. Description of the property. How much property? From which portion? 1993 when you are purchasing. That time,
No,
Milord.
they have clearly stated that it's a building which is regarding which. Building
Now,
is
Milord,
ascertainable.
1444, Milord, 1444 square link he has purchased. And the building is, Milord, constructed over 4,355 square
No, that
feet.
is also a question regarding title of the land
Title, that is,
licensor.
Milord, for that is at least on this point, Milord, could have been remanded.
No, Mr.
What or an application, Milord, and an advocate inspection commission should have been, Milord, appointed to ascertain as to what extent the plaintiff is getting his land.
And you have also not challenged the schedule of the suit.
Milord, I have kindly see, I have paragraph 7. I have filed one application under order 8 rule 9 that was rejected.
That is different.
Milord, I was debarred. Kindly see paragraph 16. Order 8 rule 9 has been rejected. I tried my level best, but, Milord, everything, Milord, goes.
No, Mr. Abdullah.
Kindly see.
No, the present second appeal arises out of a judgment of affirmance. Both the courts below granted eviction against the appellant on the ground that the appellant is a licensee. Learned counsel for the appellant seeks to argue that in the first appellate court, an application under Order 41 Rule 27 of the Code of Civil Procedure was filed seeking to introduce documents regarding acquisition of the suit property by the government, which would denude the plaintiff from title. Furthermore, the description of the suit property in the plaint is vague, which also ought to have entailed dismissal of the suit. Next para, learned counsel seeks to argue further that the appellant had pending suits for declaration of their tenancy rights. Next para. Upon a perusal of the impugned judgments and decrees, we find that the premise on which the introduction of additional evidence was refuted by the appellate court was that the defendant stroke appellant was barred by section 116 of the Indian Evidence Act from disputing the title of their inductor. Next para. Be it a landlord-tenant relationship or a licensor-licensee relationship, the rigors of section 116 of the Evidence Act are squarely applicable. As such, the appellant is debarred from disputing the title of the admitted inductor of the appellant. Next para, insofar as the description of the suit premises is concerned, we do not find from the written statement any specific dispute as to the schedule of the plaint. Moreover, the schedule of the plaint clearly relates the suit to a clearly described building full stop, next para. As such, comma, we do not find that the schedule of the plaintiff was of such a vague nature that it should have resulted in dismissal of the suit as a whole. Full stop. In such view of the matter, comma, we do not find any substantial question of law involved. Accordingly, SAT 141 of 2025 is dismissed under Order 14 Rule 11 of the Code of Civil Procedure. Consequentially, Can 1 of 2025 is also dismissed. No orders to cost. Sorry, Mr. We'll have to rise. We have a bench. 4:30 matter. Is anybody present? Child production. Acha, 4:30
matter. I'm led by
yes. Child reproduction, not production.
Yes.
Reproduction is very difficult in court. Child production matter 4:30. Please tell your other side as well as you, whoever is leading you, that please bring the child to my chamber. It's in the Sesquicentenary building, 6th floor.
Okay, Lord.
If you ask any of the people there, they'll be telling you. So bring the child sharp at 4:30 in my chamber. And we may have an interaction. Justice Kumar and I would have an interaction with the child without you or the parents, maybe. But please come at 4:30 to my chamber.
Okay, Lordship.
Thank you.
Consequently, the stay application also dismissed.
Which one?
This one.
Previous one?
45.
Yes, Mr. Rai knows that.
Yes, that has been ordered.
Great,